Morning, everyone. Welcome to the DC Court of Appeals. We have three cases this morning on our calendar. The first of them is In Re M.W. number 23 FS 588. We'll hear first from counsel for appellant.
Thank you, Your Honor. Good morning. My name is Amy Phillips, and I represent Appellant M.W. in this matter. I'd like to reserve 3 minutes for rebuttal. The statements that eyewitness Arrington Archie made to police were admissible hearsay, crucial to the presentation of the defense in this case. I'd like to focus my arguments first on the statements that Mr. Archie made to Officer Freeman, although I'm happy to address the statements he made to Officer Gramieri as well. First, the argument for the admission of the Freeman statements is preserved. The court was fairly apprised of the issue and denied the motion, which is all that's necessary for preservation. Second, as to the merits, the Freeman statements are a clear example of present sense impression. Finally, the error in denying admission of the statements was not harmless in this case. So I'd like to begin by talking about the preservation issue. On March 1st, during the trial, defense counsel introduced the statements from Officer Freeman, telling the court what the statements were and letting the court know that those statements came closer in time to the incident in question than the statements they had previously been discussing, the statements Mr. Archie made to Officer Gramieri. In doing so, and in proffering those statements to the court, she was letting the court know that she wanted to introduce those statements as substantive evidence. The court at that point, however, refused to hear the proffer and refused to watch the video that she had proffered of those statements in order to give himself a firm factual foundation on which to make a decision about the admission of the statements.
Can I ask you, it seemed at least at times that defense counsel was referring to the earlier statement to Officer Freeman as a kind of some of the circumstances that supported admission of the later body-worn camera footage. Do you agree that at times that was what the purpose was in referring to that earlier statement?
I do think so. I think it was both. I think what's clear is that counsel understood that the Freeman statements provided context for the statements to Officer Gramieri, assuaging some of the court's concerns, for example, about the timing of those statements, about whether Mr. Archie actually had been an eyewitness to the incident that he was describing to Officer Gramieri. But in addition, by proffering the statements, by asking the court to watch the video, she was asking him to admit them as substantive evidence.
Well, why do you say that? If you're acknowledging that there was at least one other reason why counsel was referring to them, what other, it seems that if that's true, then the mere fact of referring to them doesn't itself communicate that there was a second purpose. And so what would you point to as other indications, other than the mere reference to it, as other indications that there was a purpose of independently admitting that?
So I think the statement, so we also have what's perhaps a closer in time statement, is asking the court to look at that statement to evaluate it as evidence. However, if on March 1st it was unclear to the trial court that that's what she was doing, it was certainly clear to the trial court on March 8th when she filed her motion for reconsideration. Because on March 8th, in the motion to reconsider, the first sentence in the law section on page 3 of that motion asked the court, quote, in considering whether or not the proffered statements both to Officer Gramieri and to Officer Freeman may be admitted. And then she lays out the case law that explains why the court should watch the video, that explains why the court is permitted to consider hearsay and proffers in determining whether or not such evidence is admissible, and laying out clearly the law that governs whether or not hearsay statements are admissible under these circumstances.
So at that point, was trial counsel defense counsel asking the court to admit or to have Officer Freeman testify versus admitting the extended portion of the body-worn camera in which Officer Freeman tells the other two officers what happened? Because the latter has a double hearsay problem. And to the extent Officer Freeman is telling the other two officers on the body-worn camera what Mr. Archie said to him previously, that is separated in time, right? So we've got the same timing problem that we would have for a present sense impression or an excited utterance at that point, as opposed to getting in Officer Freeman on the stand himself, which I realize is ultimately what happened. But
I agree with the court about that. And I think trial counsel addresses that on March 1st when she's talking about proffering Officer Gramieri as a witness. She explains to the court, I have Officer Gramieri here today. I don't have Officer Freeman here today, but I can have Officer Gramieri testify about what he witnessed. And then if we need him, I can bring Officer Freeman in later. So I think she was anticipating the problem that Your Honor has brought up and saying, look, I can't give you Officer Freeman today, but if we need Officer Freeman, we can make him available for the trial.
But I guess, I mean, with respect to preservation, that's what I'm not entirely understanding is why wasn't this from the very beginning? I mean, it almost seems as if trial counsel had not watched the entire body worn camera footage, but otherwise, why wasn't this just bring in Officer Freeman, get him to testify about what Mr. Archie told him? To the extent that hearsay, it's clearly a present sense impression, end of story. This seemed very afterward, after the fact.
When the trial began, Mr. Archie was under subpoena. And so I think trial counsel's expectation when the trial started was that she would call Mr. Archie as a witness and Mr. Archie would be able to testify directly about what he saw. It wasn't until Mr. Archie didn't appear for trial, didn't appear on the second day of trial, they were having problems locating him. This trial started on February 27th, and Mr. Archie didn't ultimately show up in court until March 13th. So I think trial counsel at various points found herself without evidence that she had reasonably expected to have at the start of the trial because she had issued a valid subpoena for this witness. And did end up in a position where the witnesses she would need sort of as a backup if someone doesn't comply with the subpoena weren't in court on the day that she might need them, which is why she was offering to bring them in on the next court date.
Can I ask you about back to the wording of the written motion to reconsider? I agree with you. The statement that you refer to is helpful to you on the issue of whether this topic was raised in the trial court. But there are other parts, a number of other parts of the written motion to reconsider that don't seem as helpful and that seem instead to be worded as though there's only a single statement that is sought to be admitted. So the word, it's singular a lot of times. And so do you agree that there are parts of the motion to reconsider that seem to be seeking the admission only of a single statement rather than we are trying to get in two statements? Here are the two statements.
I think that the way that I would characterize that is the statements that Mr. Archie made to Officer Gramieri and the statement he made to Officer Freeman for the purposes of this trial are the same statement.
Oh, they seem
There's
a fair bit of dispute about what's on the body worn camera footage and exactly what Mr. Archie says in it, as opposed to what Officer Freeman's testimony was. So they seem pretty. One seemed a lot more helpful to the defense than the other, at least at first blush. You disagree?
I'm sorry, I'm not sure I understand the court's question. Are you
Well,
asking about?
I think you're saying they're the same statement. I thought Officer Freeman's testimony about Mr. Archie's statement is pretty clear about what Mr. Archie said he saw and where he saw it coming from. Whereas the body worn camera footage where Mr. Archie is speaking seems much less clear about those topics.
And I think when I say they're the same statement, I don't mean that Mr. Archie repeated the same words verbatim twice. But I think from the defense's perspective, what the defense needed in order to be able to put on the defense of M.W. was the statement from Mr. Archie that the bullets didn't come from the Jeep in this case, they came from the dark colored Nissan. To that end, the statements to Officer Gramieri and the statements to Officer Freeman serve the same purpose. And so when she's asking to admit a hearsay statement that's been videotaped, any of those statements will do for that purpose. So she's saying, please admit the videotape, the statement on the videotape.
I get that thought, I guess, but just to give an example of why I thought the written motion to reconsider was at least ambiguous on what defense counsel was seeking to introduce and what's seeking reconsideration. I'm thinking on page 3.10, where it says that your client asked the court to reconsider the admissibility of the eyewitness's statement as captured on body worn camera under the excited utterance exception. And so we're talking now about the statement as captured on body worn camera, not like the statement as reflected by testimony that we expect to elicit from Officer Freeman. So there are just a bunch of places where what is referred to in the singular is the statement that is, it's either, the body worn camera statement or something like that. So
And I think
You understand the concern?
I understand the court's concern. I do think, however, that any question as to what she was asking is cleared up in the very next paragraph after what Your Honor refers to, which is the statement in considering whether or not the proffered statements both to Officer Gramieri and to Officer Freeman may be admitted, and then
Which,
laying out.
I mean, again, in some contrast to the point you were making earlier, that place is using the plural and treating them as different statements. Can I ask you a related question, I guess, which is, one topic of issue preservation is how clearly a request is communicated to the trial court. Another topic of issue preservation is how clear it is, if at all, that the trial court actually ruled on a component of a request. And so where would you point us to as a place where the trial court ruled, I am not letting in the testimony of Officer Freeman about what Mr. Archie said immediately after the shooting, or within 2 minutes, depending on which formulation you use?
I think the clearest place that that happens is on March 13th. So on March 13th is the date that Mr. Archie finally does appear in court, having been retrieved by the Marshal Service. And the court asks counsel, are you withdrawing your motion, meaning the motion to reconsider? Trial counsel asks to table that motion, and the court denies the request to table that motion and says, and this is on page 4 of the March 13th transcript. Well, I'm going to suggest a different approach with respect to that motion. We have the witness. The court has ruled 3 times already that it was inadmissible substantive evidence. The court is going to rule for the 4th time that it's inadmissible substantive evidence. And I think the clearest sentence that we have here is your motion for reconsideration is denied.
Yeah, I guess, but whether that is the trial court ruling on 2 requests, one being for the body worn camera footage and one being for testimony from Officer Freeman, turns, I guess, in part on what we were just discussing, of whether the motion for reconsideration itself clearly enough communicated that there were 2 requests. And cutting the other way is, and the trial court saying, I've ruled on this 4 times. And if the first time that the idea that there was a second request for testimony from Officer Freeman is in the motion to reconsider, then the trial court isn't really ruling on that's not even so much a motion to reconsider. That's like, this may not have been clear, but by the way, we have a second request and you haven't ruled on it yet, please rule on it. So it seems like here too, that it's somewhat unclear whether this point was being ruled on, but whether the trial court understood, oh, there are 2 requests, I am denying both of them.
I think one of the fair purposes for filing a motion to reconsider is if counsel is unsure whether or not she's received a ruling sufficient to preserve the issue. That's what trial counsel did in this case. And when the judge says your motion for reconsideration is denied, he's denying the motion in full. And I think that's sufficient for preservation under our case law.
Counsel, I have a sort of a fundamental overarching question, which I guess doesn't go to Officer Freeman's testimony, nor perhaps doesn't go to the legal question of admissibility, but more just to weight or the actual content of the evidence. But I mean, your own brief's recitation of what Mr. Archie said in the body worn camera footage does not convey that the shots came from the Nissan. And I mean, your brief repeatedly says that that's what he said, but your own quotation of what he said just doesn't say that. And I don't see it in this case as him having said that.
I think that that he says it in both statements. I think that if you read or watch the videotape of the statement that he made to Officer Gramieri, what he describes is the dark in color Nissan Altima, which we know to be the car the complainants were driving from all of the other evidence in this case, driving past him, and bullets then hitting the ground directly in front of his foot. And he says they were fired. And when he says that, he's referring to the car that they've been talking about the entire time, the car that the officers just asked him about the license plate for. So I think that's the first instance that we have where he says, this is the car that did the shooting. But I think he says it even more clearly in Officer Freeman's.
Just to be clear, what you just said, he says this was the car that was doing the shooting is your paraphrase of what you're not saying those exact words could be extracted from the audio on the body worn camera footage.
No, what he says on the body worn camera, course indulgence.
I mean, so he says the car drove up the street. It was a black Nissan Altima. That's probably, I mean, I'm assuming that that's the only car that he saw. And then, you know, a few seconds later, in response to some questions, he says, they shot down at the ground because it hit the ground in front of me. And I mean, I think it requires some leap. How big a leap, you know, we can debate all day. But it requires some leap from, you know, what the antecedent today is. It may have just been an absent antecedent and we don't know who he was referring to, but I mean, we don't know. So, but I'm not sure I have a question there, but it's just not as clear to me that he's actually says what you're saying he said, at least in that recording.
And I think I have three responses to that. The first is the question that he was asked directly before was about the license plate of the Nissan Altima. And so when he says they shot down at the ground, he's referring to the same car that he and the officer have been talking about all the time, the same car that the officer just asked him for the license plate for. But I think it becomes even more clear what he's saying to Officer Gramieri if we look at the earlier in time statement that he made to Officer Freeman. Because Officer Freeman's recitation of it is that he told Officer Freeman, Officer Freeman says, I heard gunshots, and then the gentleman over there pointing in the direction of Mr. Archie came to me. He saw a black car shooting at the ground. And Officer Freeman confirms when he ultimately testifies in this case that yes, that's what this witness told him. The black car was shooting at the ground. And so I think that statement both tells us what the statement to Officer Freeman would have done for this case had it been rightly admitted, but it also provides additional context that makes clear that when he's saying to Officer Gramieri, they shot down at the ground, the they is the black car.
Can you just remind me what the time frame is for the statement to Officer Freeman? For some reason, within 2 minutes is in my mind. Can you remind me what we know about that?
Yes. So when Mr. Archie testifies, he says he thinks it was within about 2 minutes. Officer Gramieri appears on scene, and we know that from the timestamp on the body worn camera, less than 6 minutes after the shot spotter alert. And by that time, Mr. Archie has not only spoken to Officer Freeman, but has also made it all the way back up the hill to his car.
Do we have any other context clues? I mean, this is all kind of a preponderance of the evidence question. But about what Mr. Archie, I mean, you can see from the video where he talks to Mr. Gramieri, where to Officer Gramieri and where the bullet hit the ground. You can see the corner mark right there.
Yes.
Is the evidence, you know, after those shots, do we have something to say? I walked right over there, you know, kind of trying to bring in how close in time do you think you could pin the statement to Officer Freeman to the shooting?
The statement to Officer Freeman?
Yes, to Officer Freeman.
I think it's within 2 minutes. And I think we get that both from Mr. Archie, but also from the fact that what Officer Freeman says is, when I heard the shots, I came out of the store. I heard gunshots. I came out of the store and that gentleman over there came and told me. He doesn't indicate that there's any gap in time, that he was standing around waiting. He didn't have time to radio or call 911.
Let's say I thought 2 minutes is too long for a present sense impression. It's no longer close enough in time to be something that you're presently describing. Let's say, you know, I think our cases say, you know, a minute is probably fine. Do you think by a preponderance of the evidence, we could say this would most likely happen within a minute, given that testimony or not?
So first of all, I think that I don't know that we could get it within a minute, but I think that if we said 2 minutes was too long, this jurisdiction would be at odds, not only with cases that we've cited in other cases, but also with nearly every other jurisdiction in the country.
Can I ask you just on the time frame aspect of it? I may be misrecollecting. I thought either Mr. Archie or Officer Freeman also used the adverb immediately to describe the statement that was made by to Officer Freeman by Mr. Archie, something like, you know, we heard the shot and immediately he told me. So I may be misrecollecting that, but I have that impression. Do you have that impression, or that isn't ringing a bell?
But if that's how the court remembers it, I am certainly happy to have that be the.
Well, you wouldn't want it if it was made up, probably, but.
Another factual question that again may not go to admissibility, but I'm a little confused about. So if Officer Freeman said he came out of the store when he heard the shots, and then that's when he talked to Mr. Archie. I mean, the footage from the altercation in the parking lot shows that he was already outside with a couple other individuals, heard the gunshots. And then he ran into the store. So seems to undermine, and again, maybe that just goes to the weight of, if he had been allowed to testify, that would just go to weight, but can you just clarify that factual question?
I'm sorry, you're referring to Officer Freeman going into the store or?
Right. So Officer Freeman was still outside after everyone left the parking lot. And then it looks like he and two other individuals that were standing there heard gunshots still outside and then ran inside. But it seems to be that his testimony was he was inside the store when he heard the gunshots and came out. And that seems to be contradicted by the video.
And I think that was his testimony, is that he heard the gunshots and then came out of the store. I think there are individuals who are outside the store. It wasn't immediately clear to me that you could tell who they were.
Well, he was definitely outside the store and jumped when, I mean, you can't hear the gunshots, but everyone seems to agree that that's when the gunshots occurred. In the video of the argument, he's clearly outside the store when the gunshots are fired.
Oh, he was definitely outside the store at the time of the argument.
No, but at the time the gunshots are fired, he stayed outside the store. I mean, I'll go back and look, but I'm 90% sure from what I
Yeah,
recall.
well, and back on the word immediate too, but relatedly, on page 8 of the, I think, the March 13th transcript, he says, he says he sees like a spark hitting the ground, and he says immediately after you saw that shot, and is a little unclear, and you spoke to an officer on scene. So that's where I was getting the word immediately from, although the word "and" makes that a little unclear. And then he says, I spoke to this officer, talking about 30 minutes, and then walked back into the store and continued what I was doing, which suggests he was outside, I guess.
So I think on page 8, that's Mr. Archie testifying.
Oh.
So Mr.
Oh,
Archie
yeah.
is testifying.
Right. You're talking about now Officer Freeman, where Officer Freeman was located, right?
Right. And the court is correct. Mr. Archie does say, and the question is, Mr. Archie, immediately after you saw that shot, you spoke to an officer on scene. And then he answers, sort of explaining how he knows Officer Freeman.
Yeah,
But
you're right. This is not it doesn't clarify the question of where
No, I
Officer
don't think
Freeman
it
was at the
does.
time. You're right.
And to your question, Your Honor, I think you're right that may be a question that goes to weight. That may be a question that Officer Freeman could be cross-examined on, about whether he's mistaken about whether he was inside or outside the store when he heard the shots. I don't know that that undermines fundamentally the statement that Mr. Archie made to him, especially given that Mr. Archie makes that same statement or statements consistent with each other twice within less than 6 minutes after nearly being shot in the foot.
Can I ask, we haven't discussed another component of issue preservation, which I guess might have been item 1 on your list here, but your opponents argue, let's hold off on issue preservation. I know you had a list and we haven't really we've worked into aspects of the merits, but and your time is running low. If you have a couple more topics you want to address before we move on.
I appreciate that. I think just the second thing I wanted to address is that the statement to Officer Freeman certainly falls squarely within the case law on present sense impression. It's a statement about something that Mr. Archie witnessed that's made immediately thereafter. But as the court pointed out, Mr. Archie himself uses the word immediately, but within 2 minutes falls very clearly within the case law that's been adopted by nearly every jurisdiction in the country. In fact, it appears that in 2022, the Utah Supreme Court says that they looked for at federal courts across the country, and they said they couldn't find a single federal court that had disapproved of a present sense impression within 4 to 5 minutes after the incident. So I think that sort of tells us what kind of time frame we're looking at for present sense impression. And I think that for the question of whether Mr. Archie actually witnessed the event, both the fact that he was on scene and able to talk to these officers so quickly after, but more importantly, the fact that facts that we know to be true about what cars were there, about what time the shots were fired, are all consistent with Mr. Archie's statement itself. If the court had rightly reviewed all of the evidence, had believed that he could consider hearsay, for example, in determining whether the hearsay is admissible, if he had believed that he could consider those proffers, and if he had applied the correct test, he would have understood that that hearsay evidence, both at 2 minutes and at less than 6 minutes, is admissible present sense impression.
So you seem to be suggesting that reversal is warranted purely on the Officer Freeman piece and on harmlessness as to that piece, lack of harmlessness as to that piece, without going to the body worn camera footage. Is that Is that right?
I think that with regard to the statement to Officer Freeman, because we have a proffer from counsel, an uncontested proffer as to what the remainder of the video showed, as well as the statement from Officer Freeman in his ultimate testimony in the trial about what the statement was, that is enough for the court to have gleaned what the statement was. And had the court applied the correct test, what the court kept doing was repeating over and over again these concerns about, I don't know who this is, I don't know what it is, I don't know when, I don't know where. That's not the test for present sense impression. But additionally, that is information the court had available to it if it had understood that the hearsay and the proffers were admissible as part of the decision the court had to make about the ultimate trial admissibility of the evidence. And
Can I
think
ask
this-
you if we've talked a lot about issue preservation with respect to the testimony from Officer Freeman about Mr. Archie's statement. If the court were of the view that that point was not adequately preserved in the trial court, is it your view that reversal nonetheless would be warranted under a plain error type analysis?
Yes. I think this is a case in which this is very clearly a present sense impression, certainly more clearly than with regard to Officer Gramieri's statement, but even that falls very squarely within the case law that we have available to us about what a present sense impression is and when it should be admitted.
Assuming that's correct, the shifting to a plain error analysis would increase the burden that your client would have to show the prejudicial effect of the exclusion of that testimony. But I take it from your answer, which I'm giving you an opportunity to be more concrete about, that you think that your client could carry that not only a harmlessness, refuting harmlessness, but also establishing the kind of prejudice required under the third part of the plain error test.
Yes. And I think that the reason for that, it becomes clear if you start to think about what the closing argument and what the verdict would have looked like in a case where this evidence had been admissible. This is a case in which, because of the fact this evidence wasn't admissible, trial counsel was essentially constrained to just argue reasonable doubt. Had trial counsel had evidence available to her that an uninvolved eyewitness, in fact, the only dispassionate eyewitness in this case, said it wasn't M.W.'s car that the gunshots were fired from. It was, in fact, the car that the complainants were driving, the car that the only civilian eyewitnesses who are accusing M.W. were driving. That's where the shots came from. This becomes a very different case.
I mean, but harmlessness is always a little strange in bench trials, right? Because we have the comments of the judge, and we don't have to theorize about what a jury might have done. And putting aside admissibility, the judge here clearly thought that Mr. Archie was, we don't know what he said, we don't know who he was, we don't know what his angle was. I'm not saying those questions were necessarily right, but how can we factor that into a harmlessness analysis when we basically know that the trial judge was dismissing anything that Mr. Archie had said here?
So I think there's two answers to that. And the first is that had the trial court correctly ruled that this hearsay evidence was admissible, then in the portion of the trial where the relevant witnesses testified, namely Officer Gramieri and Officer Freeman, she could have laid the foundation that would have satisfied the judge's questions about that in a way that he actually would have heard. Because I think the problem here is that the judge wasn't listening to the arguments that she was making. And the way that we know that is he raises all of these concerns about, well, we don't know when this was, we don't know where it was, but the answers to those questions actually are clear from the record that's been presented to this court. We know when it was from the timestamp on the video. We know where it was because the government itself introduced photographs that match the video in terms of where the location was. We know who Mr. Archie is because the court issued a material witness warrant for him. I think those are all things that had the trial court not prevented her from introducing this evidence would have been part of the foundation at the time that the evidence was introduced at trial and would have been made more clear. Instead, what happened is both when Officer Gramieri testified at the motions hearing and when Officer Freeman testified in the trial himself, every time she tried to elicit any more than, I think there's a section where the judge says, you can only ask this one leading question. That wouldn't have been the case in a trial where this evidence was admissible. She would have been able to ask those questions and establish those facts.
Yeah, I guess I'm just asking sort of a much more general question, which is at bottom, the trial court basically said here, I'm not buying it. I mean, this guy we don't know what he saw, and I don't see him saying what you think he said on the body worn camera footage at least. And it's just not doing much for me. And I don't know how we factor that in, if at all, on a harmlessness inquiry.
So I think there's 2 points about that. The first is the trial court didn't actually hear the statement from Officer Freeman until the very end of the trial. It was one of the last things that happened in the trial that Officer Freeman testified as to what the actual statement was. Counsel had proffered it a number of times, but the trial court didn't seem to be factoring those proffers into his decision. So I think when he hears it as witness testimony, it comes in very differently. But I also think that when counsel makes her closing argument and when the judge is rendering a verdict, you'd have to think about the way in which a statement like that would change the view of all of the other evidence. Because one of the things the trial judge says in his verdict is, I believe the witnesses on everything that matters. But there were substantial problems with the witness's testimony. For example, Mr. Boyd testified that he felt a bullet whizzing past his face. That's just not something that could have happened based on the fact that there weren't any holes in the car that came into the passenger compartment. There were 5 bullet holes in the back of the car. ShotSpotter says there were 3 bullets. There were only 3 shell casings recovered. And yet there are 5 bullet holes in the back of the car. And that's an inconsistency that no one can explain, but that is consistent with the idea that 3 bullets were fired that night from the Nissan, and that the 5 holes that are in the back of the Nissan, by the time they called the police the next morning, with a fairly flimsy explanation for why they chose to delay calling the police so long, that those bullet holes are unrelated.
Do we
to this
have the
case.
ShotSpotter recording, or just, there's just testimony that they heard 3 shots?
There's just testimony
Okay.
about it. I don't believe it was ever introduced, but it was uncontested.
Okay.
And so I think those kinds of things start to take on a much greater meaning when you have evidence to suggest that these complainants have a motive to lie. One of these complainants is someone who has previously committed car insurance fraud by damaging her own car and trying to make a false claim for damage to it. And that's the same witness who testifies that one of the bullet holes in the back of her car is larger than the others, which again is inconsistent with a single shooter firing 3 shots into the back of her car all at one time. I think these are all questions that would have had to go into the judge's verdict. And we know that the judge didn't.
You may be about to say what I was going to ask, so I apologize, but I was trying to pull it up. I don't 100% remember, so maybe you can help me. Did the trial court refer to Officer Freeman's testimony about Mr. Archie and Mr. Archer's testimony in rendering its verdict?
No, the trial court did not.
I did.
One of the things the trial court did do in his verdict that I think is helpful to this court is lay out all of the alternative scenarios of MW's innocence that he considered and rejected in convicting MW. One of those is that he said he considered whether or not the people in the Nissan got out of their car, fired at the back of it, got back into their car, and then continued driving back up Howard Road. And he concluded that that didn't happen. But one scenario he did not consider was the scenario that actually is the defense theory in this case, that those bullet holes are unrelated. Unfortunately, there's a lot of gunfire in DC, and there are a lot of people who can't afford to fix their cars. Those bullet holes could have come from anywhere, but he didn't consider the scenario that the bullet holes came from, or sorry, that the casings that were found on the ground came from the Nissan, as Mr. Archie says.
Thank you, counsel. We've used up your time, but we will give you your 3 minutes in rebuttal.
Thank you, Your Honors.
You're now for counsel for the district.
Good morning and may it please the court. Ann Dang for the District of Columbia. The trial court did not abuse its discretion when it excluded Archie's statement to Officer Gramieri on the body-worn camera. Among other reasons, nothing in the record suggests that Archie spoke spontaneously or contemporaneously, and the error was harmless. I'd like to start, if I may, with the preservation issue, because that seems to be the focus of a lot of the discussion this morning. There are 2 video clips on the body-worn camera. There's the video clip of Archie speaking to Officer Gramieri, and then there's a later in time video clip of Officer Freeman speaking to Officer Gramieri. Those are 2 different video clips, and they're 2 different speakers. They're not the same statement. And we make a number of arguments in our brief on pages 28 through 30 about why this is waived.
Can you just clarify one thing? There's a
yes.
third statement then. So those are two statements. You're quite
Yes.
right. There's a third statement, which was not on body worn camera footage, but later was testified to for impeachment purposes, which is the statement that Officer Freeman testifies Mr. Archie made to Officer Freeman. That's yet a third statement. Or do you agree in terms of just keeping track of what statements we're talking about? That's a third item on the checklist.
Yes, Your Honor is exactly right, but that was never moved into evidence. The only way that third statement could have been introduced
Well, it wasn't, I thought it was introduced for impeachment purposes.
for impeachment purposes, sorry, for substantive evidence. The only way that statement could have been introduced as substantive evidence is to question Archie or Officer Freeman directly about what that statement was, because there was no body worn camera footage of Archie speaking to Officer Freeman. The only video we have of anything that is somewhat related to that statement is Officer Freeman speaking to Officer Gramieri about what Archie had said to him.
I want to make sure I understand the point you were just making. I thought that when Mr. Archie was on the stand, defense counsel, when trying to impeach his testimony that he didn't recall where the shots were coming from, attempted to refer to the testimony to what later came to be testimony from Officer Freeman about the statement that Officer Freeman said Mr. Archie made, in which Mr. Archie said he did know where the shots came from, and that the trial judge precluded that cross-examination. Am I misrecollecting that?
The defense counsel did ask Archie whether or not he told Officer Freeman that a Nissan fired the shots, and Archie said, "No, ma'am." And then when Officer Freeman,
Over an objection, and then I guess there was a question, it was sustained, and there was a question whether it was being stricken, or am I making all that up?
yes, you can pull that up. And then when Officer Freeman came on the stand, that question was never asked. Let's see. And so anyways, I'll find it, but the four motions were only about the body worn camera footage. There was nothing in any of the four motions about bringing Officer Freeman on the stand or bring Archie on the stand to
Well,
testify.
I mean, why would they get into exactly how they're going to elicit the statement? I mean, the motion to reconsider at least, and I thought in the March 1st transcript, they plainly refer to the statements to Mr. Freeman as being statements that they wanted to get in as present sense impression. What am I missing? I mean, they're pointing me to part of their motion to reconsider. They refer to the statements to Officer Freeman as things they were seeking to admit.
Yes, so the motion to reconsider on March 8th, this is a quote from what their motion was. It says that the defense asks this court to reconsider the admissibility of the eyewitness's statement as captured on the body worn camera. It was very clear that the defense wanted to introduce the video footage of the body worn camera. It was clear from their first motion when they presented the video clip for the court to watch. And then it was apparent in further motions when they kept pushing that same video clip.
I mean, it might be apparent that they were trying to get those video clips in. That doesn't make it unapparent that they weren't also trying to get into the statements to Officer Freeman, as they explicitly say at page 3 of their motion for reconsideration. They say, in considering whether or not the proffered statements, both to Officer Gramieri and to Officer Freeman, there's only one statement to Officer Freeman that they might be referring to, which is Mr. Archie's statement to Officer Freeman that was not videotaped. So why isn't that clear enough that they're trying to get that in?
I mean, it is ultimately the defense's burden to at least elicit a foundation for Officer Freeman's statement. I mean, we don't know anything about.
Was there an objection to they're not going to be able to prove up the foundation? Was it precluded because they didn't have the foundation? I mean, if they had been asked, they would have said, well, put Freeman on the stand.
Freeman did come on the stand on the last day of trial.
And they weren't allowed to ask him about that.
The court did not prevent any foundational questions.
Right, but I guess the question is, if the trial court had said, with respect to the body worn camera footage, this is, and Mr. Freeman's statement in it, this is double hearsay, and well, I don't know if it's the first or second level of hearsay. The level of hearsay in which he relays in the body worn camera footage that he spoke to Mr. Archie is preclusive here. I would get that ruling, but to the extent the court ruled that Mr. Archie's statement to Officer Freeman was itself a present sense impression, that seems to have foreclosed once and for all MW's opportunity to present Mr. Freeman as a substantive witness, regardless of any, second level of hearsay, because it wasn't going to come in even under Mr. Freeman's testimony. Is that right?
So I agree that that would only be one level of hearsay, but the defense never once alerted the trial court that they wanted to bring Officer Freeman's statement in.
Yeah,
about
but I
her-
guess what I'm saying is if the trial court was saying it's too bad it's not a present sense impression, then MW is kind of like, well, I'm out of luck. I can't put him on the stand anyway. So why would they continue? I mean, I guess they could have continued to ask for it, but they already had.
I think that would be an incorrect reading of the record, Your Honor. When the trial court denied the motions, it said that the video clip was not coming in. So it was very clear what the trial court was ruling on. The trial court was specific as to the video clip. It did not say that the defense cannot put Officer Freeman on the stand and question Officer Freeman about what Archie had said to him that night.
You said the defense never once alerted the trial court to the idea that they wanted to call Officer Freeman, but the passage from the motion to reconsider that Judge Deal referred to a minute ago seems to me hard to square with that, where it is in considering whether or not the proffered statements, both to Officer Gramieri and to Officer Freeman, may be admitted. So what could it mean other than the proffered statement of Mr. Archie to Officer Freeman was sought to be admitted? It seems like that sentence is at least once where the idea of admitting Officer Freeman's account of the statement that Mr. Archie made to Officer Freeman was the subject of the request for admission.
Yeah, so I think this needs to be viewed in context of the broader four motions. Remember that this
Well,
is a
before you get to
motion.
context, because you had originally said never once was it brought to the trial court's attention.
Yes,
Consider
and I
at least in
stand by that.
isolation, would you agree that seems to be a request to elicit testimony from Officer Freeman about Mr. Archie's statement to Officer Freeman? Again, consider it in isolation, which I know we shouldn't ultimately do, but that's part of trying to figure out what this means, is kind of understanding what it means. It would be normally read in isolation.
I think that it would be ambiguous if we read in isolation, which I don't think we should, because Officer Freeman made two statements. He made a statement to Officer Gramieri, and he also made and then
This is
also
a
Archie
statement
made a.
to Officer Freeman. The wording here is a statement to Officer Freeman, not by Officer Freeman.
Sure, but I think, again, in the context of this, it's a motion to reconsider a decision that the trial court made on March 1st. And I think it's undisputed that in the March 1st hearing, the defense counsel presented Officer Freeman's statement to Officer Gramieri. I think that is undisputed, that the motion, to the extent there was one which we dispute, was only Officer Freeman's statement to Officer Gramieri. The defense presented a video clip of that interaction.
I thought there was a reference to the statement to Officer Freeman in the discussion. So it depends what you mean by presented, I guess. But there was reference, I thought, to not only the body worn camera discussion between Officer Freeman and Officer Gramieri, or Michael, I forget which one, but I thought, do you recall this or disagree that there was also discussion of the statement that Mr. Archie made to Officer Freeman
The only.
in the March 1st colloquy?
Yeah, so the defense does reference that they could bring Officer Freeman in, but they are specific that they could call Officer Freeman in to, quote, complete the impeachment. I think that is hardly a clear motion for the trial court to admit Officer Freeman's testimony about Archie. I mean, it says complete the impeachment. That, by definition, is not substantive evidence.
Can I ask you, moving on for a minute from issue preservation to the merits, do you disagree that if the issue had been clearly presented to the trial court, that Officer Freeman's testimony about what Mr. Archie said would have to be properly admitted as a present sense impression?
I disagree with that because all we know from the record is that Archie made a statement to Officer Freeman less than 2 minutes after the shooting occurred. We have no other context for this. If this court were to find that a trial court abused its discretion by not.
Context, what context? I mean, I guess I have two related questions. One is, it seems like there is some other context. I mean, we know where it took place. We have other evidence about shootings. And so there's a fair bit of other context, but
Sure.
What context, assuming for a moment that you don't literally mean there was no other context, what context do you think was lacking that would have been, the trial court could have insisted upon as a prerequisite to proper admission?
Yeah, so it would have been helpful to know what Archie's demeanor was when he spoke to Officer Freeman. That is critical to the excited utterance.
My
exception
question
of
is not
police.
a present sense
Yes,
impression right now.
and I think it also would have been helpful to know how these statements were elicited. Did Archie come to Officer Freeman and blurt out what he had just seen, or did Archie only speak in response to police questioning?
I think it's quite fair to say it would have been helpful. I guess it seems to me there's a fair bit of distance between there were additional circumstances that would have been helpful and the absence of them would permit a trial court in their absence to decline to admit a present sense impression. I mean, are you aware of authority for the idea that if you take what was given here and what was missing here, but if you, let's say, again, if we had a clear request at the end of the testimony, both of Mr. Archie and of Officer Freeman by the defense counsel to say, in your view, for the first time clearly, okay, now that this has all happened, we have enough here that this should be admitted as a present sense impression, not solely to impeach. And if the trial court had said no, are you aware of cases that would support the idea that that would have been a permissible exercise of discretion?
Yeah, so in this court, there are not that many cases about the present sense impression between the district and appellant. We cite 3 relevant cases, none of which actually speak to the spontaneity or contemporaneity analysis. But I think this court's analysis in Mahan is at least instructive. That's an excited utterance case, but it analyzed the spontaneity prong. And in note 13, it said that the spontaneity prong applies to both present sense impression and excited utterance. And in that case, the declarant, 0 minutes had passed in that case. The declarant was speaking on the phone to the police about somebody who was currently stalking and threatening him. And the court said that that was not enough to show spontaneity because, and this is the reasoning that this court gave, the declarant gave deliberative and responsive answers to police questioning. So I don't think this question of whether or not Archie spoke only because the police questioned him is something that would have been nice to have, but not essential. In fact, Mahan would say it's the exact opposite.
I mean,
We needed this
that seems very
information.
relevant to the excited utterance because part of the inquiry for an excited utterance is are somebody's faculties stilled or are they instead responding to questioning? When I look at the terms of the present sense impression, it doesn't say anything like that. I mean, if we're just looking at the federal rule, which I think we've effectively adopted, it's a statement describing or explaining an event or condition made while immediately after the declarant perceived it. It doesn't ask for any other factors.
Yeah,
I mean, and if I'm not mistaken, I don't remember, maybe, but I thought in Sims, the statement, which was about a minute after a shooting, I thought that was also made in response. It was definitely to police who arrived on the scene, and I thought it was in response to a question.
yes, and that the court there said that that was not a present sense impression, but it did rule on personal knowledge grounds because it wasn't convinced that the declarant had actually seen the shooting. But I will say that in Hallam's, which is this court's case about the present sense impression, it says that a present sense impression must be truly spontaneous and not a conscious reflection or recall from memory. This court in Brown also declined to apply a bright line rule to how many minutes is too much for a present sense impression. So I think if this court were to say that because Archie spoke to Officer Freeman less than 2 minutes after the shooting occurred, it is therefore a present sense impression, that would run contrary to this court's instruction in Brown and in Hallam's.
But
Well,
sorry. go
Well, I mean, the fact that there's not a bright line rule about how many minutes is too much doesn't mean there's not a bright line rule about how much is too little. I mean, I think it would be fair to say we could say there's never been a case where 5 seconds was too much to be a present sense impression, right?
I mean,
I don't think you'd ever find a court that said that.
I also would like to dispute something my friend said earlier about how no federal case has said that 5 minutes was too little. We actually have a case from the 8th Circuit Manfire, MANFRE, and there wasn't a specific, there wasn't any indication in this case about how much time there was, but we do know that there was an intervening Walker Drive, and the court said that it declined to extend the present sense impression exception to cover a declarant's relatively recent memories. The classic present sense impression is somebody narrating events as they are occurring. Of course, courts in their discretion sometimes have been able to expand that time frame when the circumstances warrant it, but that doesn't mean that it's an abuse of discretion whenever a court does not choose to depart from this classic present sense impression, especially when there are so many other issues with the statement.
But so there was no questioning, I looked, but I can't remember now, when Mr. Officer Freeman was on the stand, albeit for impeachment purposes, there were no questions one way or the other as to whether Mr. Archie's statements to him were volunteered or elicited
That
by
is
him?
correct, Your Honor. We have no information about that.
And I guess your argument is that because it was the defendant's burden, that cuts against him?
That is exactly correct. And appellant argues that it would have been futile to try that, but the court has never prevented any foundational questions. In fact, they have required it. And so at the very minimum, they could have asked, what Archie's demeanor was, or, Officer Freeman, how did Archie come to share the statement with you? They could have at least laid a foundation to preserve this issue for appellate review. And the defense didn't. So now we are working with almost no information in the record about.
I mean, I guess
Archie's-
the way it actually played out, they would have only been able to do that in a proffer, because once they were limited to questioning Officer Freeman solely for impeachment purposes, they no longer had a reason to elicit the type of information that would support its admissibility as a present sense impression at that point, right?
Well, so the district disputes that the defense could not have tried to elicit Officer Freeman's testimony about what Archie had said to him. We argue that the trial court's rulings, excluding the statement, was exclusively the body-worn camera footage. Our position is that the district did not say anything as to whether or not they could have questioned Officer Freeman on the stand about what Archie had said. That would only be one layer of hearsay. That is a different statement. As Judge McLeese noted, there are 3 statements here. The 4 motions in the record were all about the video clip. And we argue that it was
And
only
all
one
is,
video
to
clip,
my
but
mind, all is a little of an overstatement, because there's at least one sentence in the written
Sure.
motion that is referring to the statement that Mr. Archie made to Officer Freeman.
sure, but this court has also said that to preserve an issue, a party must articulate its argument with sufficient specificity so that the trial court is fairly apprised as to the question on which he is being asked to the rule. And the reason for this is because it promotes fairness to the opposing party who can respond if necessary. It encourages informed decision-making, and it enables the trial judge to address the situation without jettisoning the trial. And so, yes, we dispute whether this one parenthetical may have been a motion for Officer Freeman to come and testify, but that is hardly a clear motion.
And just on the merits aspect of it, your position seems to boil down to the following. So let me just see if this is a fair characterization of your position. Your position is, if the record in front of a trial court is that either immediately and or within 2 minutes of an event, a hearsay declarant says to a testifying witness, "I saw X," and the record is silent about the demeanor of the declarant and about whether the declarant's statement was unprompted by any questioning or might have been prompted by a questioning, you think it would be within, if that's the record, it's within the trial court's discretion to say, I don't think the proponent of this evidence has adequately established the predicate for the admission of this as a present sense impression. Is that a fair description of your position on the merits?
Yes, it is the defense's burden to show by preponderance of the evidence that the hearsay requirements are met. And I don't think it shows by preponderance of the evidence that a statement was a present sense impression merely because it was said less than 2 minutes after the incident occurred. Again, Hallam says that it can't be a conscious reflection or recall from memory. I don't know what the less than 2 minutes would tell you about whether or not it is a recall from memory. There are plenty of statements that are made less than 2 minutes after something has happened that is based on memory.
I mean,
And
I'm not a psychologist, but I find myself a little flummoxed by the idea that if it's not required to be description as it happens, I'm not quite sure that it would be, it's not obvious to me that anytime there's delay, there isn't memory involved. I don't really know. I don't know enough
yes, but
neuropsychology and the like to understand that comment from our decision in Hallam's.
I also want to emphasize that it's abuse of discretion. So I'm not saying that a trial court would abuse its discretion necessarily if it admitted a statement made less than 2 minutes after an incident occurred. and there was
But
no
is
other
it- is it-
information, but I don't think it would be an abuse of discretion to exclude it.
I have that thought, but just again, to summarize a little bit about the case law aspect of it, is it fair to say that as I summarized your position about what or would or wouldn't be an abuse of discretion on the hypothetical record I described, which is, I think, your view of what this case's record is, you can't really point us to any factually comparable case where a court said it was not an abuse of discretion to admit a hearsay statement like that. I know you have general propositions that you think bear on it, but in terms of like pointing us to a factually comparable case where a court says, yeah, it's true, it was almost immediately thereafter, but we don't know anything about demeanor and we don't know anything about questioning, and therefore it was not an abuse of discretion. It'd be an appellate court saying it was not an abuse of discretion for the trial judge to exclude it on those grounds. So you can't really point us to a case that looks like that.
There's no case that looks like that, but I also don't think that's the right question. I think the right question is whether there is any case out there where a trial court excluded a statement made less than, say, 2 minutes after an incident occurred, and an appellate court found that that was an abuse of discretion. That would mirror what I think Your Honor is asking. And no, we have not cited any cases. An appellant has not cited any cases where that is the case. And so I think it's just, like a trial court has some discretion to expand the time frame, but it also doesn't have to if it seems that the circumstances don't warrant it. And then I think in my remaining time, I see my time is up, but I just want to wrap up by saying that there is another independent basis on which this court can affirm, and that is harmlessness. Overwhelming evidence supported the government's case. There is testimony from 2 witnesses which said that the Jeep shot at the Nissan, and the trial court found that credible, which this court only reviews for clear error. This is corroborated by surveillance video, which shows that the cars left in the manner that the witnesses testified, and it also shows people ducking for cover mere seconds after the Jeep exited the parking spot. There are 3 bullet casings that were found, all consistent with where the Jeep was at the time of the shooting and inconsistent with where the Nissan was. And finally, there are bullet holes in the back of the Nissan. Any error was harmless.
How many bullet holes are in the back of the Nissan?
There are 3 bullet holes in the back of the Nissan.
Oh, there were
And-
3, but I mean, there were at least 3, right? I thought there were 5.
Yes, at least 3. Sorry, there are 3 bullet casings, and then between, I think 3 to 5, I think was maybe the testimony, but up to 5 bullet holes in the Nissan.
That, though, if the number isn't certainly 3, the circumstantial corroboration seems less tight.
Yes, and I think the court did consider that, but it said that the evidence was consistent as to the central theory of the case. It's undisputed that shots were fired that night. It is also undisputed that there were bullet casings found and that they were all found at the location where the Jeep was, and that no bullet casings were found where the Nissan
I mean, it
was.
seems like if there are 2 extra bullet holes in the back of the Nissan, I mean, we're not going to relitigate here, but 2 extra bullet holes in the back of the Nissan, that suggests that there were pre-existing bullet holes in the back of the Nissan, which then immediately undermines the notion that the shots came that night.
That the shots came, well.
Though that the holes were created that night.
Yeah, so I guess 2 points. We don't know what happened to other bullet casings. We don't know if it fell in the car or if the police just didn't find them. But also, I'm actually glad you raised this. I want to correct a misstatement of the record that my friend had made earlier. She said that the trial court never considered their theory that the bullet casings came perhaps from a prior shooting, or that it had rolled down when the Nissan had fired the shots. That is not correct. On page 66 of the March 13th hearing, the court considered exactly that theory and said that it was too coincidental for all the bullet casings to have landed at precisely the location of where the Jeep was if it had rolled down. And it was also too coincidental that all the bullet casings from a prior incident just happened to be where the Jeep was when the shooting occurred. So the trial court directly considered that theory. If the court has no further questions, we ask this court to affirm.
Thank you, counsel. Ms. Phillips, you have 3 minutes in rebuttal.
Thank you, Your Honors. I think I just have 2 points. The first is the government introduced an exhibit showing that there are in fact 5 bullet holes in the back of the Nissan the next day when the complainants finally called the police. That evidence is undisputed at trial. Secondly, I think that when the court was asking questions about the trial judge's treatment of the testimony of Mr. Archie and Officer Freeman, I think it is instructive for this court to look at the way in which the trial court was treating those witnesses. This is a judge who is behaving at that stage of the trial as though he has already ruled that the Freeman statements are inadmissible as substantive evidence. If the judge didn't believe that he had already made that ruling, then there's no reason, for example, when trial counsel asks Mr. Archie, and isn't it true that you saw that black car shooting at the ground? Answer, no, ma'am. For the trial judge not only to sustain an objection to that statement, but also to strike it from the record. There's also no reason for the trial judge when Officer Freeman is testifying, and this is on page 20 of that transcript, the trial counsel asked the question, what did Mr. Archie tell you?
Can I just ask what you think's going on with that first thing you're pointing out?
Yes.
I mean, that has nothing to do with hearsay at all, though. The question is just, isn't it true that you saw the black car shooting at the ground? Why on earth? I have no idea what the objection, I mean, there is no stated objection. On the transcript, there's actually a sustained before an objection, but I can't imagine what the objection would be to that.
I can't imagine either.
But it doesn't seem like a hearsay. It doesn't seem like it could be hearsay, though. He's asking not. No, I suppose isn't it true? Maybe, I mean, you can lead an adverse witness though. Anyway, it's not clear to me that that is sort of indicative of I've already excluded hearsay, because it's actually just excluding the witness's current first-hand answer to the question.
And I think the point is less about what specific objection the judge believed he was sustaining before it was made, and more so about the fact that it's clear at that point that this judge believes that a statement that Mr. Archie made to Officer Freeman that night is not admissible as substantive evidence. And therefore, anytime trial counsel gets anywhere near trying to elicit that statement, either from Mr. Archie or from Officer Freeman, she gets cut off, because the trial judge has made clear that that's not admissible.
That particular one, I mean, there is no stated basis for the objection, but I had been speculating, I guess. I mean, the question is, do you have an impression of where you believe the gunshots originated? And you could speculate or infer, depending on which way you wanted to look at it, that seemed a little attenuated about, what's your impression about your belief? So that's sort of what I've been, that particular one, if that's the only exhibit you had on the list, I might not draw the same inference about why the trial judge was reacting the way the trial judge did to that question.
And I think the exchange I was looking at was the one on page 12.
Oh, I'm sorry.
Question, isn't it true that you saw that black car shooting at the ground? Answer, no, ma'am. But I think in addition, just a few pages later on page 20.
That's the puzzling one where there's no objection. Yeah,
Yes.
I got that one. Yes.
And I think on page 20, we get an even clearer picture of this. In questioning Officer Freeman, trial counsel asked, what did Mr. Archie tell you he saw that night? The government says objection, hearsay, and that objection is sustained.
I'm sorry. I was so focused on your first response to my question that I missed what your reference to the second. Where were we talking on the transcript for your second point?
Yes, Your Honor. I'm on page 20, and this is during the testimony of Officer Freeman at the very end of the trial. And so at line 9 on page 20, the question is, what did Mr. Archie tell you that he saw that night? Objection, hearsay, and the court sustains that objection.
Right. And that I thought seemed to maybe be the trial court not, at least as I would have thought it, not necessarily correctly understanding the sequence in which you have to do completing impeachment and the like. But
And that may be true, but the objection that was made was a hearsay objection. That hearsay objection was sustained. That is the judge making a ruling that the answer to that question would be hearsay, and that hearsay would be inadmissible. So that is a ruling that the judge made that is in error in this case. I think if the court has no further questions, we would ask the court to reverse.
thank you, counsel, for your briefs and your arguments. The case is now submitted.
Thank you, Your Honor.
We'll call the second case on today's calendar. That is DWAYNE and Davidson versus United States. It's number 23 CM 939.
Morning, may it please the court. Adrian Madsen on behalf of appellant Dwayne Davidson. I'd like to reserve 3 minutes for rebuttal. Your Honor, I'd like to start with the sufficiency issues. The reason being that if the court agrees with me on those, of course, any retrial would be barred, his convictions would be vacated, and there would be no need to address the further claims of error. So the evidence in this case, starting particularly with the attempted possession of a prohibited weapon, was insufficient to support Mr. Davidson's conviction for several reasons. One, that being that the kick was not, or excuse me, that the shod foot was not likely to produce death or great bodily harm by the use made of it, where one, there was a single kick at issue. Two, there was no evidence regarding the material of Mr. Davidson's footwear. Three, the government did not present any testimony from a medical expert. Four, there was no evidence of any lasting effects from the kick. Five, there was no evidence that Mr. Young, the complainant who was kicked, who did not testify, required stitches. And five, the trial court expressly declined to find that Mr. Davidson was the cause of any injuries to Mr. Young because there was evidence that a co-defendant who was not tried with Mr. Davidson and Mr. Allen was kicking the complainant.
So as I understand it, the trial court's reasoning for convicting on that offense was that it was likely to lead to unconsciousness, a kick to the head being capable, or at least posing a substantial risk of leading to unconsciousness. What's your view about, could you just kind of flesh out what you think the relevant legal standard is? Because sometimes when we say, was this likely to lead to unconsciousness, we mean more likely than not. I would think not. But then again, we have cases like Pringle, for instance, where it was a kick to the butt, knowing nothing about the shoe other than it was a Timberland, and it was not a sufficient. It was a plea withdrawal claim, but we did seem to say, plea withdrawal on the basis that there was insufficient evidence to support the conviction. And I don't know how anybody could conclude that a kick to the butt is likely to lead to great bodily injury, but we seem to conclude it there. Ergo must also be sufficient here is one line of thinking.
So a few responses, Your Honor. One is and as discussed in the brief, so the trial court, the finding the trial court ends up making in applying a incorrect legal standard that that issue is raised below, is that there was a substantial risk of unconsciousness, and the trial court in doing that was conflating the substantial risk of death, which can be one form of great bodily injury, with unconsciousness. And so the government says in its brief here that the standard that should be applied is that whether a person, quote, took a substantial step beyond preparation toward using the object in a manner likely to cause great bodily injury. And I just want to note that that's not what, even in attempted possession of a prohibited weapon cases, including shotfoot cases, that's not what this court has done in analyzing the likelihood. They haven't said, was there a substantial step toward this? So I'd point the court to Alfaro, cited in the brief. There, obviously, that's a phone cord, but, quote, when the object was used is not a dangerous weapon per se, the prosecution must prove that the object is one which is likely to produce death or great bodily injury by the use made of it. And so
sometimes we do use the shorthand use made of it, but do you agree that it's not just that, but it's as we sometimes also say, it can be the manner of the actual threatened or intended use?
So I think that I guess I would draw a distinction between the actual use and the threatened use. I mean, I know there's the sort of not briefed here, but the line of attempted PPW cases addressing knives, for example, where this court has found that, it makes a difference whether the knife is open or whether the knife is closed. So when you say actual or threatened, I think obviously all of this is aimed at determining whether the person had the intent to use it unlawfully, right? And we're sort of, working back from there. But so I would.
My question is sort of in a way a stare decisis type question. Sometimes we say we focus on the use, and other times we have cases where we say, a number of them, where we say that the framework is not just actual use, but actual threatened or intended use.
So I guess first I'll start by saying, that hasn't been briefed here, so I don't want to get too far out ahead of it. But typically the court's practice would be to the extent there's conflict, would be to follow the earlier decision. Again, since it's not briefed, I'm not necessarily in a position to address that, but I do want to go back for just a moment to make sure that I answered Judge Steele's question. So I agree certainly in Pringle in the plea withdrawal case that this court does find the evidence sufficient from the kick to the butt. One distinction which sort of is a theme of several of this course cases is that there we knew the brand of the boot, which I infer that maybe this is lurking in the record.
Yeah,
that
I don't think that was a fair inference. When you said a steel-toed Timberland boot, I mean, steel-toe doesn't appear in the opinion, and I don't know enough about Timberlands, and I'm quite sure Mike Farrell didn't either to tell you if they are always steel-toed.
That is a fair point, Your Honor. I would, in terms of going to the Shadfoot cases on attempted PPWB, we do have Informant, which I acknowledge is not Pringle, but we do have steel-toed boots there and repeated kicks. We have also in in LM, we have the repeated kicks to the head.
Yeah, we certainly have worse cases, to use a loaded adjective there, but I guess the question is still, how would you distinguish Pringle, which, why does it not control here?
Sure. So one is I'll sort of, I won't press the point further, but both in additional to this court's case, which I believe is Foreman, there is a reference to steel-toed Timberland boots. So I think the inference is there that they are steel-toed boots. In Foreman, I take Your Honor's point, but
Can I offer you a different distinction just to see what you think about it? Pringle referred to the standard as whether or not it was capable of causing great bodily injury. Never does it intone the phrase likely. And it seems to me from the court's discussion that the parties agree that capable of causing great bodily injury is the relevant standard. And I think one argument you make in your brief is that is not the relevant standard. To figure out if that's right, you have to trace back to, and I went as far back to Tatum, I think, the 1940 case, which is what I think Scott, if that's the 1968 case, is citing to when it says both. It says, it needs to be likely, emphasis, likely to create great bodily injury. And the next sentence is, and so capable is enough. Like, well, that's not the thing I would draw, but it seems like we've said it. So do you want to point me to what you think, if we're doing what's the real standard and we have to trace back the lineage of our precedents to like what's actually grappled with this and announce the relevant standard, what you think it is and what case I should look toward to being, this is the first in time that has really never been reassessed in a meaningful way?
Sure.
I know that's a lot. And the answer can be no, I haven't done that.
The answer is no, I haven't done that.
Okay.
The answer is I'd be happy to submit supplemental authority on that. What I will say is that in this court has, in articulating the standard sense, that the court, I acknowledge the opinion in Pringle, what seems to be an outlier has repeatedly in the context of attempted possession of a prohibited weapon cases, both Shadfoot and otherwise, and ADW cases for that matter, right, which Pringle was, that the standard is likely to cause as opposed to
Can I ask you just to complicate this already complicated thing more? When you emphasize the idea of likely, it seems to be implicit in your reference to that term that you would understand it to mean more likely than not. So the word likely here is meaning greater than 50% probability. There is definitely case law in various other settings that indicates that likely is an ambiguous term, and sometimes it means that, but other times it means things less than that. And so what sort of further complicating this is what seems like, at least in other settings, the ambiguity of the word likely as between more likely than not and degrees of likelihood that are less than that. Do you have what makes you in this setting or more generally take as the meaning that we have been applying or should apply to likely that it is probable in the sense of more, 50, greater than 50%? probability.
So I would agree that this court's decisions on dangerous weapon, whether that's in the context of attempted PPW or whether that's context of ADW, don't address sort of that distinction specifically. I'm not aware of a case addressing that narrow issue. What I would say is that in Stroman, and then later sort of, in Covington, pointing back to Stroman, the court makes a distinction in saying, well, giving the example of the hitting in the head with the flip flop there, that is an object that is not the fact that it may have caused an injury which wasn't serious injury, which the court ultimately held anyway, that it wasn't likely to do that, where contrasted with something that may be very likely to do that, as I believe the language is in the footnote from Covington, is that there's certainly nothing to say clearly in any of the court's cases that likely means less than 50%, right? There's nothing saying it means a reasonable probability,
I mean,
right? There's something certainly. You
could think of the case that Judge Taylor is referring to, which says likely and then says capable, is communicating the idea that the greater than 50% meaning of likely must not have been what the court was thinking about, or else it had a somewhat unusual meaning of the word capable in mind. So that'd be at least one indication. And that's not, I guess if that's Tatum, that's a DC Circuit case. So, in this jurisdiction and binding on us to the extent it's still good law.
Yes, sir. And again, I'm not aware of any of this court's cases specifically addressing this issue. Again, I'd be happy to.
A related topic to even further complicate it. Right now I'm blanking on the precise case in which I believe this is true, but I have the recollection that at least in one or more of our PPWB, ADW cases about items that are not intrinsically weapons and may have been transformed into them by their use, threatened use, actual use, some or all of the above, that we seem to have equated and worked in the idea of substantial risk into our characterization of the standard, seeming to equate likelihood and substantial risk, which would be a not unreasonable equation if likely is being used in a less than 50% form of meaning.
So I agree, Your Honor, in terms of what that is, in terms of what great bodily injury is, that includes things that are a substantial risk of death, right?
That's a confusing. I don't mean to interrupt you. I did mean to interrupt you. I apologize for interrupting you. It would be a better way of saying it, but the matter is more complicated by the point you're making, which is the definition. This also our law has evolved on. Back in the old days, we used phrases like great bodily injury and serious bodily injury, and the degree of actual or threatened or intended injury didn't seem to be very stringent. There are some old cases where somebody throws a piece of wood at somebody and doesn't seem to have hurt them, and that was treated as sufficient to convert the wood into a weapon. Alfaro definitely seems to, one could, I guess, raise questions, though no one has here, about whether Alfaro was free to do this. But Alfaro definitely kind of adopts into this area a much more stringent definition of serious bodily injury. And then there is, and part of that definition of serious bodily injury has the phrase substantial risk in it, modifying only death and not the other pieces of it. That's all well settled. But if likely to cause serious bodily injury, if the word likely has substantial risk in it, it's earlier in the process, not only, and would be about death and all the rest of it. So substantial risk might be cropping up in multiple places if you fit all the pieces together. But I take your point that substantial risk is a concept that is partially included in the now operative definition of serious bodily injury for this purpose. That's true, but I'm not sure that fully addresses the question of whether substantial risk is earlier in the fully developed idea, which is what is the likelihood of serious bodily injury.
Yes, Your Honor. I guess my only point in saying that is that the trial court here, and I at least take the government to be conceding this point from their brief, applied that if the standard was that in terms of showing great bodily injury, that substantial risk of unconsciousness would not suffice.
Well, it doesn't suffice to be serious bodily injury.
Yes.
But if if conduct is likely to cause serious bodily injury that creates a substantial risk of any of the listed items, then a substantial risk of unconsciousness would ultimately work. Actually, what you would need a substantial risk of death and a substantial risk of the rest of the things listed. And I take the United States to be arguing, they at one point say, one could debate the use of the word logical in the sentence in their brief, but they say that substantial risk logically implies likelihood. I'm not sure I would use the word logically to describe that, but at least it potentially does, depending on how you're interpreting the word likely.
Yes, sir. I just said that they don't cite any authority, certainly, for that proposition, right? That substantial risk and likely are equivalent,
That is true.
Just turning briefly to the, I'll rest on the brief regarding, given where I see my time is, regarding the trial court erring in failing to prove in finding that the government proved beyond a reasonable doubt that Mr. Davidson was not acting on self-defense with regard to the simple assault. So I'd like, if I could, I'd like to spend just a few minutes turning to the second issue in the case, also related to Government Exhibit 2. That is, there were several issues here, and I think it analytically it would help to start by explaining why Government Exhibit 2 is not a business record, because I think there are a few other implications that flow from there and responses to the government's arguments. So that is in adopting 14508.
Can I ask an antecedent question, which
Yes.
is, in your view, does the business records exception have anything to do with the admissibility of the tape? In other words, is the tape hearsay that requires a business record exception as the way in which it could be admitted?
So as I've sort of said consistently all along, the video itself is not hearsay. There could be circumstances in which a video could be, but in this case, the video.
It's a silent video, so it has no words in it, right?
It both has no words and it has no gestures, right? There are the example, right? But so I only mean to say that the video here itself is not hearsay.
So does that mean you don't think it needs to be a business record to have been admissible? It's not hearsay, and the question here really is an authentication question rather than a hearsay exception question.
So I agree that there is an authentication question. What I mean to say is that in seeking, I guess to respond most directly to your Honor's point, in seeking to authenticate it, the government relied on these non-testifying technicians' hearsay statements, and
which are definitely not business records and are not, and I don't think the United States is arguing those statements are business records, right?
Yes, but so what the trial court did was to find that these statements from the non-testifying technician were quote unquote subsumed within this business records exception. The only so even if those statements were being considered for purposes of authentication, the only exception that the proponent of the evidence put forward was the business records exception. That is, those statements, right? So even if the court agrees with me, right, this is not a business record and therefore we're going to authentication, the statements that the trial court relied on to do that were the hearsay statements of the technician.
I understand. And so there's definitely a question about hearsay relating to those statements. I'm just wondering whether treating the tape as a business record is kind of a wrong turn, and that really the question is, how do you authenticate the non-hearsay videotape? And then you get into the questions of, well, the United States wanted to authenticate it through hearsay and through, in your view, inadmissible and testimonial hearsay, and that's not okay. But I find myself wondering whether business records has much to do with the correct analysis of the issue here.
So I largely agree, Your Honor, and sort of the reason I began there was sort of to explain why, in my view, the government's arguments are incorrect. In that, even if it was a business record, you know, as this court held in Thomas, as the Supreme Court later had it held in Melendez-Diaz, right, that doesn't answer the question of whether the Confrontation Clause is violated. So I started there, but if the court is with me analytically, I'm happy to move on to the sort of where I believe the real issue is here, which is that the statements of the non-testifying technician were plainly testimonial, right? That is, they were.
So what was the hearsay statement? Before we get to testimonial, the hearsay statement by by the record custodian.
Sure. So this is on on October 24th, page 78. Okay, and how was government's exhibit 2 obtained? The technician actually went out, pulled it, reported it, brought it back, downloaded, and preserved it.
So how is that hearsay?
So as we go later from that, and then beginning on the cross, when the trial court revisits its objection, the Ms. Robinson, who was the testifying witness, explains that the only way she knows that is because he told her that.
Okay, but well, I'm not sure that's right, factually. But even putting that aside, at that point in direct, we don't have a statement that's hearsay standing on its own, right?
I disagree, Your Honor. That is.
Well, I mean, it's only hearsay if you assume at that point that the only way she could know that is because someone told her. I mean, let's say we have a witness who's testifying that, I'm sorry, I keep cutting you off, not letting you answer, but suppose we have a witness who says it was cold on the day of the crime. And everyone in the courtroom knows that that witness wasn't there. So the assumption is that the witness must have been told that it was cold on the day of the crime. So defense counsel says objection, hearsay, and then there's voir dire of the witness. And the witness says, yeah, I wasn't there, but I knew it was cold on the day of the crime because I got back to my house and my pipes were frozen. Right? So it's not hearsay at that point, you would agree, right?
Sure.
So something that happens later in cross that makes it hearsay doesn't mean that it was hearsay at the time.
I disagree with that, Your Honor. That is the trial court, I guess I'll say, the way it happened, when this came up in direct didn't sort of allow a voir dire, by the defense on this issue. But I, as trial counsel below, right, said, well, I'm assuming the way she knows that is because somebody else.
Right. So
told her.
So then I'm getting to the factual, what I thought was a factual mistake in what you said. The answer she gave then was still not hearsay. She said, I knew it because I told him to pull it and it was pulled. And this was a little weird, but she said, I could have watched him doing it on our monitoring cameras. And it wasn't clear that she said, I did watch him do it. I get that. But she gave a non-hearsay reason for how she knew. Why isn't that the end of the story?
So when we come back at the beginning of cross, and she is asked in much more detail about this, but, because there's not a voir dire happening at the time of direct, she says, sort of in as many, I think several different ways, that the only reason she knows this is because he told her.
Can I ask you, why do you even need to go to the further cross? One way of looking at this, it seems at least arguably, would be that a witness says a thing and the party who is objecting to that testimony believes that the witness is not testifying from personal knowledge, says objection. I think this is hearsay. It isn't on its face hearsay, but I believe that if further inquiry will show that this is hearsay, and then there's a little bit of further inquiry and like defense counsel, ask if you could inquire to create a record as to whether there is personal knowledge or there isn't. The trial court doesn't allow you to ask, but there are a couple questions are asked that don't establish that there's personal knowledge. You could say the trial court isn't in a position to overrule the objection at that time. There's an objection and we don't know that the answer is that the objection should be overruled. We don't know whether it's personal knowledge or not. There's some things that don't seem to establish personal knowledge have been elicited, and the trial court seems to be thinking, well, I don't need to do anything further other than to determine whether facially someone has made it explicit that it's hearsay. It seems to me one could argue that ruling is incorrect as of that time because you haven't created a record that allows the trial court to know whether the objection should be sustained or overruled.
So I would agree, Your Honor, that ruling is incorrect then, but I only mean to say here we have even more than that, right? That is, here we have it then developed at the beginning of the cross, all of the reasons, which again is that the non-testifying technician, whose name I don't think we actually get through all of this, that the reason she knows these things is because he told her, and that's comes out in various ways. And so even looking beyond that error initially, right, we have it actually firmly established that the way she knows it is because he told her.
Can I ask what to make of one recurring issue briefed by the parties to a degree about that arises out of this trial is it's a bench trial. And nobody is really being very persnickety about exactly what things are happening in front of the trial judge in the trial judge's capacity as a determiner of fact, and instead in the trial court's separate capacity as gatekeeper to evidence that could be considered by the trial court in its fact-finding capacity. So some of these things that are happening here, wouldn't happen this way in a bench trial, in a jury trial, because people would be concerned about keeping, people having the information they should have and not the information they shouldn't have. Should we just kind of overlook that, or how should we respond to the fact that it just wasn't ever very clear in this trial? Nobody was objecting about the fact that it wasn't clear exactly what things were coming in front of the trial court for which of these purposes. Who should we hold that against if we think it needs to be held against somebody?
Sure. So I guess a few things. One is, to give an example, at the time that the trial court initially overrules the objection before reversing itself and then reversing itself again, the issue is raised. Well, I'm going to return to this objection on cross, right? After developing the issue, trial court says yes, that's fine. Government says silent, certainly doesn't object to that process, and certainly the government has taken the position here, albeit in a slightly different way, that trial courts in bench trials are able to segregate admissible and inadmissible evidence, and so I don't think that it is the manner in which that is happening during the trial certainly is dispositive or bears on the outcome of this case. What I mean to say is that the government sort of argues.
Well, I guess the one way it seems like it potentially does is that one of the government's arguments is information that would be testimonial hearsay and inadmissible hearsay on other grounds besides the Confrontation Clause can be put in front of the gatekeeper to the admissibility of evidence on issues of authentication or creating a record to support the application of exception to the hearsay rules. And so to the extent some of what was elicited here might have been otherwise inadmissible hearsay, or might have been even testimonial hearsay that couldn't have come in constitutionally in front of the fact finder. To the extent that might be true, that's not a problem here because A, the trial judge had a different function that allowed that information to come in front of the trial court for purposes of the gatekeeping evidentiary rulings, and B, defense counsel didn't object and say, hey, wait a minute now, you need to really carefully parse this out, Judge. You may be considering some of this in making your evidentiary rulings, but to the extent any of it is inadmissible hearsay, either under hearsay rules or under the Confrontation Clause, you may not be considering it for purposes of guilt or innocence. That objection was never made, and therefore the government tries to kind of, I think, make a set of arguments that hold against you and your client the failure to really pull those things apart and keep them separate.
So a couple of responses to go back to your first question in terms of who should the court hold that against. I mean, first, Mr. David, if the court agrees that sort of this, business records are beside the point, right? That is the reason we went down that route was because the government raised that issue below, and the trial court was addressing it. Mr. Davidson was objecting to it. It wasn't sort of on cross eliciting this for the first time gratuitously. So I think the answer is you hold that against the government. But to the second point, Mr. Davidson repeatedly and came back sort of anytime there was new information relating to it, renewed the confrontation objections, arguing that the trial court was considering the non-testifying technician statements, the testimonial hearsay. So I certainly don't think there's, and I mean, the government hasn't argued plain error here, so I don't think there's any issue of waiver there.
Can I ask? Well, they do argue, I thought, they have kind of their broad, you elicited some of this testimony and therefore you made your own bed. Now you have to lie in it and you have your argument that you're really only making the best of a prior adverse ruling. So there's that degree
Yes.
of kind of forfeiture, that argument's being made. But I thought they make a more specific argument. It might be in a footnote somewhere, but I thought they made a more specific argument about you're really not in a position to object if some of this information really should have been limited to authentication or hearsay exception use rather than guilt or innocence use, because that you never teed that issue up. Maybe I'm misrecollecting, but I thought they were also trying to hold that more narrow idea against you.
Well, I guess what I mean is by not arguing that the confrontation claim is subject to plain error, they're certainly not arguing that the confrontation objection was not preserved, and sort of going backward, that, you know, they do sort of make this general waiver argument. I think that fails for the reasons stated in the reply brief. That is, you know, Max sort of is an entirely different situation where the defense counsel sits silent despite being apprised by the trial court repeatedly. And I think we just don't have that here at all. So they're arguing a sort of different, you know, you brought this out on cross, but the point of bringing it out on cross, which happened with the government's agreement below, was to develop the objection, which should have been sustained, in my view, in the first place.
Can I ask you, it's going to end up, and I apologize, it's going to end up being a three-part harm question. Part one is, if you agree that the videotape is not itself testimonial hearsay, and this is a problem of authentication, why isn't the correct harm analysis under Kadiakos for, you know, reasonable likelihood of harm instead of Chapman needs to be harmless beyond a reasonable doubt? The second step is both related to Ms. Cologne's video, which clearly shows the end of the fight with Mr. Young down on the ground writhing for, you know, I think on the government's exhibit, it's 30 seconds. On her video, it's maybe 20 seconds before your client walks up and kicks him in the face. And so part two of the three-part question is, why isn't that evidence just to kind of make this an open and shut case? It wouldn't have affected the trial court's analysis, the government's exhibit, because you have an independent and properly authenticated video that shows the exact same thing that she relies on in reaching her verdict. And part three is a little bit of a strange question, which is, how could one have failed to authenticate government exhibit 2, ignoring all the hearsay of the custodian, when you have a properly authenticated video that shows the exact same thing? You can look at the two and say, well, obviously this government exhibit 2 is the same thing that's going on in this properly authenticated video. Authentication is just a matter of preponderance of the evidence, whether or not it's relevant. It doesn't need to be ironclad proof, good enough to authenticate the video. And so you can take those in any order that you want, but I find all those somewhat difficult, and I'm curious to hear your reactions to them.
Sure. So I guess this sort of goes to both the second and the third question. So I think I'll start with that first. But we don't have, I think, I don't want to put your words in your honor's mouth, but something to the effect you said, you know, the exact same thing. We've got in Ms. Cologne's video, right? We have a short clip that is, it sort of repeats itself, but it's I think about 2 minutes. The government exhibit 2 is about 10 minutes long, and when the trial,
Ms. Cologne's clip is the damning part. You know, that the government exhibit 2 is all the exonerating stuff that shows these two guys were jumping your clients. It's everything that you could, you definitely would have wanted to get that in if you had just had Ms. Cologne's clip.
So the trial court, in making its findings, I guess I'll sort of go in a different order here. The trial court eventually says that he has a subjectively feared bodily harm, but that belief was objectively unreasonable. She agrees with that characterization, and in finding that any fear of bodily harm was objectively unreasonable, the trial court looks back to portions of government exhibit 2 that are not in Ms. Cologne's video. That is, she says Mr. Davidson is, you know, standing on the chair, that he's acting aggressively, that he's acting erratically. And when she's making her findings, she relies on all of these other portions of government exhibit 2 that are not captured in Ms. Cologne's video in part to only credit parts of his testimony. And so the answer, I guess, to the second question is that it did impact, and certainly the government can't show that it, beyond a reasonable doubt, that it didn't impact, which I guess goes to your first question, because I mean, the trial court's findings are, sort of replete with discussion of government exhibit 2, including portions that are not in Ms. Cologne's video and that the trial court views, broadly speaking, as unfavorably to Mr. Davidson.
Yeah, but I don't think the question was, I don't think the premise of the question was that the two videos had to be coextensive in length. It was just that the portion captured in Ms. Cologne's video was sufficient to authenticate the entirety of exhibit 2 because it couldn't have shown, it clearly showed a portion of the same event, which is sufficient for the relatively low bar of authentication. I don't want to paraphrase Judge Deal, but.
So I guess I was attempting to respond to the second question, which was that, sort of why wouldn't this have impacted the trial court's verdict, right? And the answer is there is these other portions of government exhibit 2 that the trial court views unfavorably to Mr. Davidson and relies on those in finding him guilty and in part in finding that the government had proven beyond a reasonable doubt that he was not acting in self-defense. And so I guess to go to your first question in terms of the standard of harm, I guess I'll first start by saying, which I understand is a different question than is before the court, but certainly both sides have argued here that the standard of harm for confrontation clause violations, right, of course, is Chapman. But
the premise of the question, I think, was the tape itself isn't a confrontation clause violation. So that the inquiry about the damage and what standard review would apply would be what is a confrontation clause violation in your view would be the use of a testimonial hearsay about the circumstances of the creation of the tape.
Sure. I'm sorry.
Right. So
I'll just add that many of the federal cases, which I think are sort of beside the point that the government is relying on here in analyzing some of them not reaching the ultimate question when analyzing similar questions, evaluate the harm that came from the thing that was then admitted, not from the foundational statements themselves. I'm happy to, when I come back up on rebuttal, I'm happy to provide the citations for those, but that is that they, whatever type of record it was, that when the court was evaluating those, they both, evaluate the harm from the evidence that came in improperly or allegedly improperly, and evaluate that under Chapman, and that is beyond whether the government had shown it was harmless beyond a reasonable doubt.
did you want to, I think you haven't yet taken a stab at answering part 3 of Judge Steele's question, so I wanted to give you a chance to do that. Now you're over your time and
Sure. So the question was, how could if just to make sure.
There were independent bases for authentication here that one, I guess one of your arguments could be, at least to the government offers one about the timestamp on the video. So I understand your response to that. But I was offering a somewhat different take, which was, if you just look at Ms. Cologne's video, you could not help but conclude it shows the same events, and government exhibit 2 is a videotape from the same time. Now you could say, well, maybe the first 8 minutes were doctored because that wasn't captured, but that's way too high of a bar for authenticity. It's just kind of like probably the same thing. And it seems like, again, your answer might just be the government hasn't argued this, but it might come into the harm analysis where you think, well, there's just no way this wasn't going to be authenticated. I mean, they should have asked Ms. Cologne, and they didn't. But we do have the videos in front of us, and I mean, we can, I guess, sort of say this government exhibit 2 is definitely the same fight that you see. If a longer excerpt of it, it's the same fight that we see on Ms. Cologne's video, which was properly authenticated.
So I guess part of it is that I would agree that the government hasn't argued that here, so I haven't briefed it. But what I would say is that in other contexts, when this court, for example, TW Hawkins, when this court is, despite having the video in front of it, right, says, well, we're still going to review for clear error, right, even though we have the, your honors have the video for it. And so the trial court here, in making its findings, sort of relies extensively, on government's exhibit 2. And so the fact that it might have properly authenticated under some theory that the government didn't offer, it might have, it might not have. And so I don't think sort of doing that appellate fact finding on appeal would be warranted. And so with my time long expired, unless there are further questions, I'll save the remainder of the non-existent time for rebuttal.
Thank you. Now, Counsel from the United States.
Good morning, Your Honor. It's Dylan Always on behalf of the United States. So the trial court did not err in admitting the WMATA's video surveillance footage of the assault as a business record. The trial court did not err by permitting the government to elicit the foundation from Ms. Robinson, the WMATA records custodian, to lay the foundation for admission of that exhibit as a business record. And the government did adduce sufficient evidence at trial to prove both attempted possession of a prohibited weapon as well as simple assault. So I'll start where appellant starts, which is the sufficiency claim. Judge McLeese, I think you made a great point that baked into this analysis here on what standard we are going to hold attempted PPWB to encompasses likely to cause great bodily injury. And so likely not only modifies substantial risk of death, but likely also modifies unconsciousness. And I'd like to turn your Honor's attention to the actual findings of fact here by Judge Israel. Judge Israel found, as a matter of fact, that Mr. Young, after Mr. Davidson kicked him in the head with his boot, appeared to be unconscious or semi-conscious for many seconds. That after he was kicked.
Okay, can you just, my recollection was quite different, that he appeared to be unconscious or semi-conscious before the kick.
It was both before and after, Your Honor. And
I mean, if it's both before and after, then the kick doesn't really affect things.
Judge Israel had found that Mr. Young had been lying on the ground and posed no threat at that point, and that's relevant to the self-defense claim. But after the kick, and I'll
Just to be clear, she's wrong then. She's clearly wrong. He's not unconscious after the kick.
He's not unconscious. So she's saying he's lying on the ground and he's not moving. And she says after the kick, he appeared to be unconscious or semi-conscious for several seconds. After the kick, Young even attempted to raise his arm, but fell back down to the ground. And that's page 20 of the November 6th transcript. Further.
Yeah, that just makes me think she doesn't know what the word unconscious means. I mean, people can be disoriented without being unconscious. People who are trying to block kicks and standing up and stumbling around are not unconscious. They're disoriented.
Well, we disagree with the characterization that he was attempting to block a kick. He had been kicked straight in the head. And as Judge Israel found.
I was just trying to repeat what you said her finding was. I mean, I thought she says after the kick, he moves his hand to try to block the kick.
After he was kicked, after the kick, he attempted to raise his arm, but fell back down to the ground. She also said that Davidson's actions carried with them not just a great risk of unconsciousness, but an even greater risk of something very significantly more severe.
I thought you said if not even greater risk of something even more severe.
If not even greater risk of something very significantly more severe. And I'm quoting from page 21 of her.
Right. What does she mean? A greater risk of death than unconsciousness?
A fair inference from what her findings is here is something very significantly more severe than the likelihood of causing unconsciousness would be the likelihood of perhaps permanent brain damage or even death. And so based off of the factual findings, even if we were to accept appellant's view as to what the standard is here, what she has found as a factual matter is that Mr. Davidson has attempted by using his foot, and there was evidence in the record from Officer Vieira that the boot that he was wearing was a construction style boot, that he used his boot-clad foot to kick Mr. Young in the face and has caused him to not be able to move correctly afterwards. And
He couldn't move correctly beforehand. How could you make that finding?
Well, yeah, the factual finding on what he was doing beforehand was that he was lying on the ground.
I mean, you would more naturally, if I watched this video, if I wanted to, say the opposite, it would be like, it seemed to have revived him a little bit. He looked to be out before the kick, and then he seems to get a second win.
Your Honor, and again, I don't believe the appellant is arguing clear error on that factual finding as opposed to what the ultimate finding here was not did not satisfy what the standard was. But again, if what we were finding is that after he was kicked, Young attempted to raise his arm and fell back down, and that as a result of Mr. Davidson's kick to Mr. Young's head, that it carried not just a great risk of unconsciousness, but a greater risk of something very significantly more severe. What the court.
I like Judge Deal, I'm a little puzzled by if the risk of unconsciousness was X. I don't know how the risk of something more severe than unconsciousness was X plus N. I mean, what do you, I mean, if it was death, I would think that the risk of death would intrinsically be less than the risk of unconsciousness. And I'm not sure what the other more severe damages the trial court might have had in mind. Do you have some sense of what that might actually mean if you're going to be really zeroing in on exactly what it means?
I think a fair inference from what her findings was is that not only was there a great risk of unconsciousness here, but again, what his actions were in kicking Mr. Young in the head carried with it potentially more severe consequences than something worse. And in an attempted PPWB case, the government doesn't need to prove that he actually was rendered unconscious. It was just that there was a substantial taking an action that is likely to cause that. And I believe that the factual findings here from Judge Israel satisfy that standard.
And what do you think likely means in our cases in this area?
Even if we were to accept appellant's position that likely means more than 50%, that's satisfied by the court's factual findings.
That may or may not be the case, but I'm just asking the antecedent legal question of what do you think it does mean?
Again, this is an issue that it wasn't raised in the initial briefs as to whether it likely here is greater or less than 50%. As far as
I thought it was raised, if not supported by citation, but I thought there was a sentence in your brief that said when the trial court found substantial risk, that logically means likely, that it was likely. So I thought you were equating those, not citing authority for it, but I thought you.
And again, yes, we do argue that substantial risk and likely here are the same thing, but we're not reducing this to a specific percentage. I don't believe that.
I have a slightly different reading of your brief, so I want to make sure we have it clear. So I'm looking at a different sentence that proving that a victim suffered a substantial risk of unconsciousness is not sufficient to demonstrate great bodily injury. And that's at page 44 of your brief. And I understood your other statement to being, well, when she says substantial risk, what she means is likely. So kind of conceding the legal point that appellant is making that it needs to in fact be likely and saying, well, that's basically what she found. Is that right?
That's an accurate summary of our argument here. And the substantial risk was just quoting from this court's decision in Scott about saying substantial risk is only a modifier of the first thing.
But I mean, on what basis? I mean, why on earth would a judge conclude he was more likely to suffer injuries than he in fact suffered? No, he was kicked in the face. Particularly prone, he's on the precipice of being unconscious anyway. So more so than just about anybody else you would find, I think particularly susceptible to being knocked unconscious. He's kicked in the face and he's not knocked unconscious. On what basis would a trial judge say, yeah, but he probably would have been? Like, based on what? Based on our familiarity with how often kicks to the face? My layman's knowledge of kicks to the face and all the action movies I've seen and how likely they are to render somebody unconscious. I mean, I just don't know how somebody could draw that conclusion beyond a reasonable doubt.
You mean based off of the video that the government had introduced here showing that what the reaction was of Mr. Young after being kicked in the head? Right. And again, what the standard here to bring back to is in this attempted PPWB case, the question is, what is the risk and danger introduced by his actions, and whether or not we don't have to show a completed unconsciousness in order to prove the attempted possession of a prohibited weapon, just that he took the steps that are likely to result in that. And I think that it's a fair inference from the record from both looking at the force used, the nature of what he was wearing on his foot, the testimony that he was wearing a construction boot, how he reacted after the kick, there's testimony that he was taken to the hospital in order to receive injuries, that the judge could make a fair finding of fact from that record to say, yes, I believe that he has, that there was substantial steps here, likely to, by using his boot-clad foot to kick someone in the head is likely to cause
I mean,
unconsciousness.
and I go back because I looked at the sentence that Judge Deal pointed to, and I end up being quite confused about what it means in isolation or in connection with the other sentence that I was focused on. So maybe you can just clarify today what your position is. And let's leave aside for a minute the complications of attempt. And so imagine we're talking about a completed PPWB.
Sure.
So we don't add on that complexity. Do you agree, first of all, that it's a correct statement of our current law that for a defendant to have be guilty of completed PPWB with respect to an object that was not intrinsically a weapon, and therefore if it became a dangerous weapon, it was through the manner of its actual intended or threatened use, that the defendant must have actually used, intended to use, or threatened to use the object in a way that was likely to cause death or serious bodily injury? Is that a correct statement of the standard we should be applying?
In a completed PPWB, likely to cause a substantial risk of death, and then without the modifier substantial risk, unconsciousness, extreme pain, et cetera. Yes, I believe that is an accurate statement of the law.
And with taking that as an accurate statement of law, do you interpret the word likely in that statement of the governing legal principle to mean more likely than not?
I don't believe that that has been definitively held by this court. And again, this is the specific definition of likely as a percentage of over 50% or under 50% was not an argument presented in these briefs. As far as substantial risk goes, substantial
Well,
risk.
so, did you agree that whatever likely means, it is something more than substantial risk, which is how Judge Deal was suggesting? There's a sentence in your brief that says that. Do you agree that's true? Whatever likely means, it means something more than substantial risk.
That substantial risk would encompass the term likely, yes.
I'm not sure. That response leaves me unsure about the exact answer to my exact question,
Okay.
which is, you said, I asked you a question about, okay, what does likely mean in that sentence? And you said, well, the court hasn't really very well clarified and the parties haven't really briefed it. So I take those 2 points. Those are probably both 100% fair. But then I was asking, do you have a position at least about the following, which is whatever it means, is it something higher than substantial risk? And you said some things that I didn't interpret as an exact answer to that question. So that's why I'm trying again.
So based off of this court's precedent, I don't know that there's been a direct correlation between the term substantial risk and any fixed percentage. However, in the manner used in the findings here, when she's talking about a substantial risk of him falling unconscious.
Yeah, leaving aside from the findings, I don't mean to stop you ultimately from getting there.
Of course,
just back on the legal questions. First of all, is it, well, notwithstanding the uncertainty in our case law and the lack of briefing on the topic, does the United States have a position, to your knowledge, about whether likely means, what likely means, either whether it means at least 50% or whether it means something short of that? You're not, is it fair to say you don't have a position today?
I don't have a position on that today.
And do you think, if you're, to the extent your opponent has been arguing that likely means greater than 50% and you haven't suggested otherwise, we should take the case on the view that that's what, for purposes of this case, that's an undisputed principle?
If you were even, our argument is that even if you were to accept that position here, what the court's findings of fact and what the evidence introduced in that case would satisfy that.
I have that, is that your only argument, is I guess what I'm asking, because since you haven't contested it, that's the only way you could win, is not by saying, well, don't really think it's 50%, think it's less than that, and something less, here's what it is. Your only path to victory is if we assume that it requires 50%, you think a reasonable fact finder could have found it. For completed, and then adding in the complication of what substantial step might have, whatever additional leeway that creates. Is that a correct understanding of your positions?
Yeah, yes, with again, the modification here or the modifier here that these precise percentage of likelihood and over under 50% was not squarely presented in this brief and was not argued as far as sufficiency goes. And so even our argument here is even accepting the proposition that it would be over 50% as the appellant presented here on oral argument, the evidence here would satisfy that standard.
So you're saying a reasonable I mean, the way it kind of looks to me on the video, and feel free to correct me, the way it looks to me might be different from the way it would look to a reasonable fact finder, which I hopefully sometimes I'm reasonable. I'm definitely not a fact finder. It looks like the complaining witness is, for a while, maybe even unconscious. He seems like he's not moving at all. That he seems maybe semi-conscious or unconscious before the kick. And then he's kicked, and then it does seem as though he starts moving and he tries to get up, and then he kind of stumbles back down. You think that's a fair description of kind of the condition of the complaining witness during the relevant time frame? Or am I missing something?
I think that's a fair description of that.
And then a reasonable fact finder could look at the video and draw inferences about how strong a kick it was. You can kind of see that, and you can tell that the leg is drawn back, and then there's a kick, and you can try to get a sense of how forceful a reasonable fact finder might have thought that would be. So there's another piece of information a reasonable fact finder would have had. And then why would you, if you're going to be concrete about, a reasonable fact finder could look at that and say there was a greater than 50% chance. Again, leave aside for a minute attempted PPW and what you think additional latitude gives you, but let's imagine this was completed PPWP.
Sure.
Do you think a reasonable fact finder could have looked at this as there was a greater than 50% chance that would have caused unconsciousness?
Yes, both based off of the nature of the kick in the video, his reaction after that as captured by the video, the testimony about the type of boot that Officer Ubiera testified that Mr. Davidson was wearing, based off of the evidence that Officer Ubiera said he was taken to the hospital and treated afterwards. I think all that is fair as part of this to be able to take into account as a finder of fact to say, what was the likely result of Mr. Davidson's actions?
And let me I know in your brief at one point, you do try to argue, and I've adverted to this today, that the fact that this is an attempt offense rather than a completed offense kind of makes the case somewhat easier, the sufficiency analysis somewhat easier for you. Let's assume for a moment that I was unpersuaded that it was a greater than 50% chance that unconsciousness would be caused by that kick in the circumstances of this case. And you were going to say, okay, fine. Even if that's true, this was attempt, and therefore the defendant could be found guilty, even if it was 37% chance, which is an absurdly quantitative number, of course. Because ... How would you explain exactly how the fact that this is an attempt case would create greater latitude about the degree of likelihood that would be required?
Sure. So the attempt statute talks about taking this court's opinions have talked about taking a substantial step towards this. Now, the fact that he has reared back and with a
That would be with
construction
the
boot on
intent, so that would require that it was a substantial step towards a more serious completed offense that he may or may not have completed. And so the idea would be the fact finder would say, well, this was the first kick and he was trying to do more, and then he abandoned that and left. Or what exactly, I'm just not quite sure exactly how the substantial step idea, and substantial step is one of the formulations for attempt. It's not the predominant. I don't think it's the predominant one. There's also dangerously close to success is another formulation. So that's an additional complexity. But how does that, like, concretely, a fact finder would say, okay, yeah, if I think this wasn't completed, it was a substantial step to a completed one because the completed one was going to be further kicking, or he meant to kick harder and he didn't really connect quite the way he wanted to, or what's the detailed thinking about how you would get to the completed offense this was a substantial step towards, or that this was dangerously close to completing?
So under either of those formulations, what we are asking is, has he taken an action that is likely to result in the completed crime? And we've just had the
He
dialogue.
has to intend that it be.
And intended. So
that would be he intended to cause, the fact finder would have to find he intended to render him unconscious on this theory.
that he intended that his actions intended to cause, intended to result in the likelihood of causing a substantial
I
risk
see.
of
So the
death.
idea would be
or
he was trying to create greater than 50% chance of unconsciousness. He may have only got to 37, but a reasonable fact finder could conclude that his plan was to create a greater risk of unconsciousness that he succeeded in creating.
that his intent in rearing back with a boot-clad foot and kicking someone who's prone on the ground in the head is either dangerously close or substantial step towards taking actions that are likely to result in unconsciousness.
Do you agree with the way I just formulated it, which is the idea would be a fact finder could think, assuming a fact finder thought this didn't actually create a greater than 50% chance of unconsciousness, a fact finder could reasonably think this is an attempt crime. It has to either be a substantial step or dangerously close to a completed crime that was intended. The intended crime could have been, I was trying to kick the person harder than I did, or was trying to achieve more than I did achieve. And I was really trying to make it quite likely, or maybe I was even intending unconsciousness, and I just didn't quite get there. Is that a correct description of the mode of thinking in more concrete terms, or am I missing something?
I believe that, yes, that sounds correct from an attempt, applying the attempt statute to the PPWB standard here, Your Honor. Unless there are further questions on sufficiency, I'd like to turn to the issue of the Exhibit 2. So I do want to start with the threshold question about whether Exhibit 2 is properly authenticated as a business record. So the business records rule is both an exception to hearsay, that is the federal rule equivalent of 8036. It is also a mode of authentication. That is the equivalent of Federal Rule of Evidence 90211. That is the DC Code 14508, which talks about this admitting business records as a method of through the method of certification. And I'd also like to turn this court's attention to the Johnson case from 2023, which is when the United States sponsored a custodian from Meta to come in to authenticate Instagram videos that were posted to the defendant's account and direct messages. Now, the defendant's direct messages are not hearsay, they're statements of a party opponent here. But what Johnson did was talked about how the government was able to use the Meta custodian there to authenticate those records as business records. So whether or not the evidence could be authenticated as a business record didn't turn on whether or not a hearsay exception was applicable. It turned on whether or not a custodian could come in and say, I recognize that these are records that we keep in the regular course of business, and that these are records that came from our files and that they were recorded at or near the time of when the record was submitted.
Yeah, but in this case, it turns out that she doesn't recognize any of that. She actually thinks they're videos from a bus when she's asked, which isn't great. It's clearly a metro train. And instead she says, well, how did you know? Well, he told me. Now that comes out in cross. I take, the colloquy between Judge Schenker and Mr. Madsen to heart that, the actual direct testimony includes things like, well, because I told him to go do it. But it does seem, there could have been a proper lack of foundation because why do you think he did what you told him? Why do you think this is that? This is not a case where she says, at least not initially, well, look at the video. You can see the timestamp. That's what we use on our Ramada videos. If she had done something like, because the timestamp's removed for some reason that she can't articulate, and she can't articulate why. That would make sense if she had done something like that, but she didn't. So she doesn't sort of pretend, to my view, we could talk about the file name in a moment, if you want to talk about that. But to me, she's not saying, I recognize this to be something we keep in our files. It's, I know that it's this thing because he told me that it was this thing.
So what I disagree with that reading of the record. So what she did, and yes, there was the complication about the bus and versus train. However, the custodian of records does not need to have any knowledge of the underlying substance of the video. And that's what this court has held in Meters, and that's what this court has held in Duggan. Sure. And that's what the federal rule is too. She needs to be able to say, I can look at a file and recognize that it came from as the custodian of records, I recognize they came from our organization's files. And she did do that here. And that's what the foundational questions that the government was asking originally. Do you recognize what Exhibit 2 is? Yes, I recognize Exhibit 2 as a file that came from our records that we pulled in response.
Based on what? I mean,
again, we published Exhibit 2 for her to look at. I mean, we didn't publish it for the court.
You think what she was saying, I can tell by sort of the pixels and the way the camera is, slightly, I just don't know. I mean, usually you would say because it has some markings that we use, and that's how I can tell. But instead, it seems to me that the best reading of the evidence is she knows that it's that because she asked somebody to get it, and that person told her that's what it was.
So I'd like to separate that into two steps. The first is she could look at that video that she had produced to the government and say, this was the same piece of evidence that I produced to the government. And she recognized that. Now, she was mistaken, and it was clarified about the bus versus train, but she could still look at the video.
Why is that useful to anything? I mean, unless it's connected to something that WMATA's doing, to be able to say, I don't know what it is, but I know it's the thing I gave the government isn't really very helpful, right? The question is, does she know what it is in some sense that makes it relevant to this case? So it may be true that she said she could look at it and say, have you seen, somebody said, have you seen this before? And I say, yes, I once gave it to, I've looked at it, I gave it to the government.
Mhm.
That doesn't authenticate anything, right? So I don't know why that advances the ball. And I mean, maybe it's a step, but by itself, it's missing the other 7 steps of the stairway.
So, and again, getting to the 2 parts here. So she, as the custodian of records, would be familiar with the types of records that they keep, including surveillance video of trains and buses. Now, she also, as far as the specific authentication of this record, and again, for the business records rule, the custodian is merely authenticating not the underlying substance of the record, but that this is a record that came from the files. So with respect to how was this specific record obtained? Well, I got it from the locked evidence room after I assigned pulling the specific record to a technician, and this was the fruits of his labor. And as Judge Schenker had mentioned earlier, that was the initial testimony that she had explained.
I'm sorry, what, she said she got it from a locked room?
From the locked
Yeah.
evidence room. That
Remind me
would
where that is
be on the October 24th transcript. I believe it is at 80 to 81. I can confirm that for you.
Here we go. How is it kept? The government's exhibit 2 is kept. It's a kind of a confusing question. By WMATA, does she mean?
Yes,
And before or after it was created?
that was after the, well, I want to be careful with the use of created. After it was pulled, the
So that's like
record,
chain of custody about it?
pardon me, Your Honor?
I thought that was before it was created.
I'm trying to figure out whether, how is it kept? Meaning, how was it kept after the technician created it? Or how are things like this? Government's exhibit 2 is a copy of a thing.
That's correct, Your Honor.
So is this a question about how that copy is kept? Or is it a question about how are the videos from which the copy was taken are kept? I find the question very confusing.
The specific testimony about the locked evidence room was after the copy was downloaded by the technician. With respect to
So how does that bear on how she knows what it is? I mean, again, it's the last step up, and maybe one of them is another step, but there are still a bunch of steps missing. You'd agree, right?
Sure. So
Okay.
she explained how WMATA in the ordinary course of business is recording surveillance videos of its transportation system and recognized that this was a record of that. That was
Just
pulled.
to step back a little bit, there was a colloquy during your opponent's argument about this set of questions are right around here and a hearsay objection to whether it was correctly ruled on or denied. And I was suggesting that perhaps one could argue that the ruling was incorrect. So that if you're thinking of this as hearsay, or if you're thinking of some of what is being said here, like they pulled it, downloaded it, and preserved it, and there's a hearsay objection. And then there's some further discussion, and then the trial court says, I overrule the hearsay objection. Do you think that ruling was correct?
Yes, I do
And
believe.
how was it? How was the discussion that occurred there? How did it establish that statement, they pulled it, downloaded it, preserved it, was not hearsay?
So the judge asked Mrs. Robinson, how do you know this? And she said, first, well, I'm the supervisor. I assigned the task of pulling this record to the technician. And then second, I also have the ability to track his activities. Now, in fairness, she was also asked on cross-examination, did you have a conversation with the technician?
Yeah, I'm asking right now, before we get to cross, just
Yeah.
about the record that was created here in the trial court's ruling. So you're saying, so basically the defense attorney is saying, somebody's saying something and I don't believe it rests on personal knowledge, I'm objecting to hearsay. And so then the issue is the proponent of the evidence going to be able to persuade the trial judge as gatekeeper that actually it is either not hearsay or it is admissible hearsay? And then what is elicited is, so the statement is they pulled it, downloaded it, preserved it. And what's elicited is I assigned it to a person. How is it kept? And then there's an objection that's never answered. Oh, I guess it says I can track, then there's an intervening question from the court about how do you know that the tech did it? And it's, I can track his activity, which doesn't establish personal knowledge. It just establishes the possibility of achieving personal knowledge, but tends to imply that it wasn't actually achieved. And then the next question is the same. And then the trial
Actually,
court says,
can we pause on that? Because the next question is, how do you track his activity? And the answer is, she's talking about
the
Mr.
bus.
Davidson.
And
She's
it's the
talking about
bus.
how she can track people getting on and off the bus, clearly not tracking the technician's activity.
Right.
Sorry.
No, that's, and it also is referring to I guess bus or train. And then the trial court says, I'm going to overrule the objection. I hear no hearsay.
So-
I don't understand how, if the objection was, this appears to be hearsay not based on personal knowledge, and then the things we learn are, I assigned it to a person, and I could track that person's activity. Maybe that person may be a different person whose conduct is depicted in the video that is the topic of this request. I don't understand how that's a record that would be sufficient to allow the trial court to sustain, to overrule an objection on hearsay grounds.
Yes, Your Honor. So if I'm understanding the question correctly, is how could she have personal knowledge based off of that foundation that was just laid?
Yes.
And personal knowledge, again, being a low bar and can be based circumstantially and based off of reasonable inferences. The reasonable inference of a supervisor assigning a specific task to someone and getting the expected result and knowledge of the process of how all of it.
Well, that's not personal knowledge. That's just an inference. That would be, the reason I believe that to be true is not because I perceived any of it, but because that's how we normally do things. And I have no reason to suppose it wasn't done the way it was normally done.
And
Which would, maybe that would be I mean, I guess that could be, you could overrule the objection saying, it's ambiguous as to whether it's personal knowledge or inference. It might be a reasonable inference. It's not facially hearsay. You can figure out on cross whether it rests on hearsay or doesn't, and we'll hear more later. None of that's explained, but that's your thinking is that the trial court could have been saying not facially hearsay, might be reasonable inference, and that could get sorted out on cross.
So as this court acknowledged in Harrison, personal knowledge can be based off of reasonable inferences and circumstantial evidence. And so what we are saying here is what she is testifying to is this is the video that was pulled because I know from my personal knowledge that I assigned this task. I know from personal knowledge that this was the record that came back as a result of that assignment. And I also know from personal knowledge as the records custodian how these records are pulled. And so she's saying, I assign this to the technician. I understand how technicians go and pull this type of evidence. And I also know from my personal knowledge that this was the specific record that I then turned over as a fruit of that labor, of the technician's labor there. And so again, with the low standard of personal knowledge and circumstances, piece of business record means that confrontation and hearsay is not a bar to being able to establish this type of evidence, this foundational evidence for a business record.
In front of the gatekeeper, or do you think you can also use it in front of the fact finder when the fact finder is trying to determine authenticity as a component of relevance?
So you can do both. So Ellis, the Seventh Circuit case, talks about how the certificates of authentication, right? No witness at all, just a certificate of authentication comes and goes with the jury. Ellis was followed by the DC Circuit's case in Adefahinti, which adopted that reasoning. And then if you look at the dissent in Melendez-Diaz, the dissent in Melendez-Diaz raises, well, I'm concerned that the majority opinion here is going to provide an impediment to this type of evidence coming in. And Justice Scalia in the majority specifically responds to that by saying, in fact, Crawford doesn't provide, it doesn't bar any, or excuse me, the confrontation clause doesn't bar this type of evidence from coming in. And so in addition to brief indulgence, Your Honor, in addition to this coming in Ellis, Yelly Davis talks about how the government was permitted to present the certificates in order to certify the authenticity of the business record.
Can I ask you, I
Yes,
just
sir.
want to make sure I understand how broadly you're arguing. So are you saying that this is something special about business record type authentication and certificates? Or are you saying it's a general truth about the relationship between the Confrontation Clause and evidence that is used to authenticate, meaning to, make something that isn't obviously relevant in some way?
And the question is specifically for in front of the in front of
Yeah,
the
in front of
jury.
the,
In front of the jury. With respect to, this is specific to a clerk or a custodian authenticating the authenticity of a record from his or her organization's files. And that's
And
what,
why in your view is what's the theoretical rationale for limiting it in that way? Why would the Confrontation Clause operate differently as to when clerks are testifying and not when people are authenticating things through lay witnesses?
so Melendez-Diaz says that this is a founding era exception to the Confrontation Clause. And so as Justice Scalia talks about, this is a narrow exception under which a clerk can by affidavit, so no testimony at all, no live testimony, no possible basis for confrontation, can say this is a record that comes in. So it's.
Right, I thought the rationale is it was the equivalent of a seal, where they used to, you put your seal on a document and you send it away, and based on what the seal looks like, you know who it came from. But this case just doesn't look anything like a seal that she's stamping on anything, because she's not the one who's getting it. She gets a thing from somebody else. She couldn't testify. She couldn't sign honestly an affidavit saying this is this time from our videotapes, which we've kept in a separate locked file that I pulled out, because she didn't do any of that. She's just basing it off of what somebody else said. She couldn't put her stamp on this thing because somebody else had to create it in anticipation of prosecution. It's not similar to, I mean, it's just not similar to a seal in the relevant sense, I don't think, in the way that a certificate of authenticity might be. It's more like a certificate of no record, which we have said is clearly testimonial and not admissible, because you're testifying to steps that somebody else took.
So I disagree with that distinction, Your Honor. So the certificate of no record is something that is specifically created for purposes of being introduced in the litigation. As this
weren't
court.
the actions testified here to for the purposes of litigation?
Sorry, Your Honor.
Weren't the actions of the technician that were testified to here by Ms. Robinson also in anticipation of litigation?
It was part of the foundation, laying the foundation for a business record.
No. I mean, the conduct itself. Why did the technician take this? Why did Ms. Robinson ask the technician to take the steps that Ms. Robinson asked the technician to take?
So it was in order to obtain a copy of a business record. So the business record itself.
I know, but if the testimony of hearsay is again the testimony of of Ms. Robinson about what the technicians told, I'm just asking. That the testimony about the actions of the technician is testimony about actions that were taken in anticipation of litigation, because the technician's actions were in anticipation of litigation. Do you disagree with that? You may not think it's legally relevant, but do you disagree that they were taken in anticipation of litigation?
To place this analytically, I believe that is part and parcel of the certification that this is a record that came in from our organization. And so again, getting back into the equivalence and turning Your Honor's attention back to Melendez-Diaz, but also the Ellis line of cases, which has been followed by almost every circuit court, that talks about how the foundational evidence, including by certification, is what can come in to do that. So if Ms. Robinson had simply signed the certificate and gone in and provided, say, we pulled these records and I can certify that Exhibit 2 attached to this record comes in, that's what the Ellis line of cases establishes, and that's what Melendez-Diaz seems to support, is saying this is not a confrontation issue.
You're well over your time. I'll give you a couple minutes if you want to wrap up before.
Yes, Your Honor. So the last point I want to make on this is to tie it back in doctrinally to this line of cases, to Melendez-Diaz, to the Ellis line of cases. What she is doing is effectively no more than what a records custodian would do by certificate. What 14508 provides, what 90211 provides, what has been repeatedly recognized as okay by federal courts, and what Melendez-Diaz establishes here under the Supreme Court. And so unless there are further questions on the confrontation issue or the sufficiency, we'd respectfully ask the court to affirm. Thank you.
Mr. Mattson, we'll give you your 3 minutes in rebuttal.
Thank you, Your Honor. I want to start first with, there was a factual question that came up about whether Mr. Young was unconscious or semi-conscious before or after the kick. I would just direct the court to page 11 of the November 6th transcript. That is, it was before the kick. That is, it was from a punch that was not charged as the assault. This is at the 8:30 mark, talking about Government's Exhibit 2. Davidson then punches Young in the head with a right hook and knocks him to the ground. Young can be seen clearly falling to the ground where he remained and where he also appeared to be unconscious or semi-conscious for many seconds. So just in terms of the factual question, the government also in arguing about the sufficiency talked about Mr. Young being taken to at least transported somewhere for medical treatment. That really has no relevance where the court didn't find that Mr. Davidson was the cause of any injury. And we had the other gentleman there, the erstwhile co-defendant kicking him. The government also relied on the Officer Ubiera's testimony characterizing these as construction style boots. And I think respectfully, that's a kind of a fairly meaningless term. When he was asked about, do you know the brand? Do you know the material? Anything about them, right? So it's sort of a general descriptor that doesn't aid the government here. There was a bit of discussion about dangerously close, substantial step. I just want to note again that this court in attempted PPWB cases has both looked at whether the object was used in a manner that was likely to cause it. Alfaro, Dorsey, Stroman, all of them. And these are all attempted PPWB cases, and this court is not saying, was this dangerously close to creating a substantial risk of this? That is, the court has actually looked at the manner in which they were used and looked at the actual injury cause, which again, the court didn't find that Mr. Davidson was the cause of here. I recognize my time is short, but just briefly, one of the reasons I think this business records discussion, frankly, is a red herring. But the point I do want to make is that the government is saying that these hearsay statements were admissible as a foundation for a business record. Again, the video is not a business record, right? And so if these statements are coming in for some purpose, and the video is not a business record, they are coming in as hearsay. And so the government sort of relies on several federal cases for this point. But as discussed in particular in the reply brief, 14508 A3A has different language than 90211, which this court had at any point not adopted, and then 8036, that is, the record was made at or near the time by or from information transmitted by someone with knowledge of the act, event, condition, opinion, or diagnosis, right? So there was no evidence that any person from WMATA had knowledge of the act or event that was depicted in there. There was also testimony, that is alone is enough to make it not a business record, but the other point is that when asked what the purpose of having these cameras were, the Ms. Robinson testified that the purpose of them was to create evidence. That was her testimony, and I'm happy to get the citation here, but that was her testimony. The government also referenced Ellis, this Seventh Circuit case. I'll note that in Ellis, in terms of the weight that this court should give to Ellis, the court's reasoning there relied on other, I believe, 9th and 10th Circuit cases finding that certificates of no record were not testimonial. So in terms of the weight you want to give to Ellis, I don't think there is much there. So for all those reasons, unless the court has further questions, I ask that Mr. Davidson's convictions be vacated or in the alternative reversed.
Thank you, counsel, for your briefs and arguments. The case is now submitted. Before we call the third case, we will take a very brief recess of, say, approximately 5 minutes. All right, we'll now call the third case on, I guess now this afternoon's calendar, number 23 CV 550, District of Columbia versus Facebook Inc.
Thank you. Good afternoon, and may it please the court. Jeremy Girton for the District of Columbia, and I'd like to reserve 2 minutes for rebuttal. There is substantial evidence that Facebook made misleading statements about its data sharing and enforcement practices and hid the truth about the Cambridge Analytica data leak for years. Facebook told users that they could use their privacy settings to limit the sharing of their information to friends only, that applications would be allowed to access data only for certain purposes, and that Facebook had robust enforcement tools like the power to audit applications. None of that was true, and those misrepresentations and omissions are all textbook CPPA violations. The Superior Court's summary judgment ruling here is wrong for 3 independent reasons. First, it misapplied the summary judgment standard and ignored material disputes of genuine disputes of material fact. Second, it misapplied the CPPA in multiple ways, such as by imposing a duty requirement and a heightened burden of proof. And third, it misapplied Rule 702 by excluding the testimony of the district's expert. This court should correct those errors and allow the district's claim to reach a jury. And I welcome the court's questions on any of those issues. But I think it probably makes sense to start with our affirmative case and the friend sharing misrepresentations in the record. And I think
Sorry, can I ask you an order of operations question first? So, I mean, you briefed the expert question second, and I'm just trying to, that's fine. I'm just trying to figure out, I mean, and I'm not previewing which way we're headed on any of this, but if we were to say that the exclusion of the expert was not an abuse of discretion, I assume it's your view that you still had enough to get past summary judgment and go to a jury.
yes, Your Honor, yes.
Okay.
So and I think either way the court comes out on that question, you kind of have 2 options that would come out in our favor. One, it could vacate the decision and say there was an abuse of discretion, or we don't have enough record to decide whether there's an abuse of discretion, and still decide the summary judgment question, kind of ignoring that evidence. If the court ruled against us on the abuse of discretion question and said the evidence was properly excluded, it could still resolve the summary judgment motion. We think there's more than enough evidence to get us past summary judgment. Or if the court agrees with us and says the evidence should have been admitted, it could consider it for part of its summary judgment analysis. But we don't think we need it for the summary judgment ruling. So starting with the friend sharing misrepresentations, I think the first place that a reasonable user would look, and this is J 1525, is the privacy settings when they're deciding how to control who had access to their information. And if you look at the screenshot on page 1525 of the JA, it says, click here to control who can see your profile. And that's under the privacy settings. That is actually inaccurate. You can't control who can see your profile by using that link, because you actually have to go to a different page, the application settings, in order to actually decide whether or not third parties are going to be able to access your profile information. But if you click on that link, then you get to a page that shows your privacy settings. And this is kind of the checkboxes of everyone can see it, or friends of friends can see it, or friends only can see it. That's on page 1526 of the record. Nothing on that page says anything about third-party applications, and nothing clues a reader in to say you actually need to go to a different page to limit third-party applications access, even if you set everything to friends only. At the bottom of the page, there's a little link to the applications settings, but it doesn't tell you that you need to go there in order to further decide who's going to have access to your information. And I think that's especially misleading, because if you look at Mark Zuckerberg's deposition testimony at 3773 of the record, he was asked about how a user would control who had access to this information. And he said you would do it through the privacy settings. Again, that is wrong. You would have to go to the application settings. Their 33-6 witness, Allison Hendricks, at 2684 also said it was controlled through the privacy settings.
I mean,
And
part of my reaction so far is who cares? I mean, so if they say you can control who accesses your information, click link A. You go to link A, you can't actually do it there. It's instead link B. I suppose that's something of a misrepresentation. Doesn't strike me as a potentially material one, because if I can actually control it, and A doesn't work, well, maybe I have to Google how to do it. But then I would, if I got frustrated because I didn't see how to do it on A, then I go to B. I mean, what import is that?
so I think the problem is if you look at 1526 and where you're kind of deciding, it gives you the impression that you actually can control and limit your information to friends only, because that's the most restrictive option that's listed there is friends only. It doesn't say friends only and all the applications that your friends use, which would be a more accurate description of that category. And it doesn't give you an option to restrict applications at all. So I think
How far you take that thought, and I mean, if you proceed in that way, one could say that even friend sharing is misleading. The option that your friends can share your information is misleading. Because if you start here and it says you can restrict your information, you can restrict it to your friends. It doesn't say, oh, by the way, your friends can then share it with other people intentionally. So do you think it's misleading even to have this box that communicates the idea that I could check this box and I can give my information to friends, but no one's told me that my friends can then go send it along everywhere else. I would think only friends can have it. It can't just go willy-nilly out into the whole interweb.
Yes, I think that the design of this page is a key part of what makes Facebook's kind of whole setup misleading, as well as its other
But I just
affirmative
want to, just
statements.
to be clear, your argument isn't limited to the idea that it's not sufficiently clear, or in some places it's affirmatively indicated otherwise, that friends who download apps may thereby make the apps available to get your information. That is the worst piece of it from your perspective. But I was just wondering whether you think it's misleading even that your friends can share your information as opposed to just your information to share with their friends, but they can't pass it along. Do you think that's independently, you haven't really argued that's kind of independently actionable. That's just, that's sort of part of your overall picture of a worse a more severe misleading, or is it really part of your argument that even allowing friends to share is misleading in light of statements like, where you start, which is you have this box, you can control everything, just say friends. But a reasonable person would think that means my friends can have it and no one else can.
I think it depends a little bit on what exactly you mean when you say friends can share. I think everyone would understand that if you share something with a friend on Facebook, they could tell someone else about that information verbally, or they could maybe take a screenshot or a picture of it and share it with the New York Times or something. But I think you've made a conscious decision when you check that box and you share something with a friend that my friend is not going to take that affirmative step to share this particular information, or at least I've kind of calculated that as part of the risk when I've decided to share whatever it is I've decided to
So
share.
you're not arguing that a reasonable user would be confused and think, I'm going to give this information to my friend when I check this box, but I would assume that it just stays in my friend's little knowledge and would never pass from my friend's knowledge to others as a result of whatever my friend does. You're not making that-
I
you're
don't
not
think
making
you
that
would,
argument.
I don't think you would assume it would pass beyond your friend unless your friend
Well, no,
affirmatively took a
right.
step, right?
But that's not an answer that I mean, that's a different argument. I'm just asking, you're not arguing that a reasonable person would be misled to think that a friend, if I share information with my friend, it will stay only with my friend rather than through some processes be spread from my friend to others. You're not
No,
arguing that.
no,
explicitly.
we're not making
And
that
what your
broad of an
argument is, I guess, that some friend spreading reasonable users would infer or understand and wouldn't be misled by, even though it says friends only in the first level, but others wouldn't. And it's that if I understand where you draw the line,
Mhm.
it is, you think reasonable in light of, I guess, what normal people would think, and also what you would read from these materials as a whole. You would think that reasonable users would think, if I pick restrictive options, I can get it to where I will share it with my friends and they may make a conscious decision to share it with others, but they wouldn't think, they'd be misled into thinking, well, but it would always be, I'm assessing only the risk that my friend would be making a conscious decision of further sharing rather than by, downloading an app, making choices that end up causing, either knowingly by my friend or not, other people to have access to it. That's where you think that, the documents as a whole get misleading. It's that line between, conscious friend sharing and maybe conscious, maybe not friend sharing through, at least potentially not conscious friend sharing through the downloading of an app. That's
Right,
where you
right. I
it
think,
gets
I think
misleading.
it's the line
That's a
between.
pretty refined line.
Yeah, right. It is a fine line, but I think that this screen kind of talks about what information is going to automatically be shared and with whom. How can you restrict it? Kind of, it's automatic within Facebook, Facebook's universe. Where is it going to go? And I think it would take. It's a very different thing that This includes automatically all of my friends, every application that they choose to use is automatically going to
But,
kind of.
I mean,
suck in.
why does it matter that whether it's automatic or not? I mean, if the question is the risk that you're aware of or not aware of when you post something on Facebook, that, I mean, you gave a perfect example earlier yourself. I mean, your friends could take screenshots and send it around to the entire world. Once you bear that risk by joining Facebook and then sharing things, even if you think you're only sharing them with your friend, then what difference does it make at that point, whether things are automatic or your friends are choosing to do things? I don't really see that.
So I think there's two differences between an example of a friend kind of screenshotting a particular piece of information and sharing it and what was happening here. The first is that the friend has made an affirmative choice to kind of take something that you've given them and share it with someone else. And the second part is that they've chosen a particular piece of information to share versus everything on your Facebook profile, all of your details, everything you've ever liked. I mean, all of that information in theory is accessible to the friend, but they would have to go through your whole profile and your timeline and find every single post. And in theory, they could extract it if they wanted to take that conscious step and share it with someone else. But this is a much broader sweep of what kind of information is being shared. And I think that all of Facebook's other affirmative representations kind of reinforce that idea that your friend would have to take an affirmative step. If you look at the statement of rights and responsibilities, which is kind of the terms of service, which Facebook says everyone should have read really carefully and understood what was in there, it makes really broad pro-privacy statements that you have control over where your information is going to go on Facebook. You're the owner of your own data, all of those sorts of things. It has all these provisions about enforcement, which we can get to in a minute, but it says nothing about friend sharing whatsoever. It doesn't say third-party applications can access your information through your friends. It doesn't say anything about that. So you have to go another layer down into a data policy, which is.
Although again, just to be clear, you're not arguing that based on what you just said, that even the idea that your friends can share your information is so hidden that it would be misleading for Facebook to allow that to happen.
Again, I'm trying to draw a distinction between like kind of an affirmative, sending it to the New York Times,
Understood.
sharing that. I think we all agree.
I understand that,
happen.
but the document you were just referring to just doesn't even refer to friend sharing at all.
Correct.
So you could argue it's misleading even about the idea that your friends could share things and maybe you could go find it in other places. But I just, that the document doesn't mention friend sharing, I guess you're agreeing doesn't establish that friend sharing, that the failure in that document to refer to friend sharing doesn't itself make it misleading about friend sharing. You have to look at other documents, and other documents sufficiently tell you about non-automatic friend sharing in your view for it not to be misleading. But there's just not enough about automatic friend sharing or app scraping or whatever you want to call it to avoid the documents as a whole being misleading. Is that your line of thinking, or am I missing something?
I'm not sure that's quite right, Your Honor, because I think that this was such an important part of Facebook and such a critical privacy concern that it would be an actionable omission just not to mention it in the terms of service at all. So I think that could still be actionable independent of all the other statements under the CPPA under an omission theory. But I think the way that we have thought about it.
But you don't think that's true of the idea that your friends could forward information?
That your friend
Non-automatic.
forward, manually. I think that is kind of is understood just from the use of Facebook and the internet. I don't think that necessarily failure disclose that is necessarily misleading, but it's this automatic, even if you've selected friends only, it will automatically kind of get pushed out the door. And then I think you go to the data use policy, which is what they think of as their best piece of evidence on a disclosure. What it says multiple times is that applications can access your public information. They make that very clear. They use the word public many times throughout that document. That gives the impression that maybe if you even understand that friend sharing is a thing, this automatic friend sharing, that maybe it's only the public information that's going to get shared with applications, not the stuff I've selected as friends only. And it never disabuses a reader of that impression. The only time it talks about information being shared with apps, it talks about it in the context of public information that they'll get. Then it says several pages down into the document further that like email, your friend can reshare information. And I think that gets much closer to kind of what a general person would understand. Okay, if I send an email to someone.
But you're alighting over the rest of that clause, which says just like email or elsewhere on the web. I mean, I get the notion that if I email somebody, I don't expect it to be then disseminated unless they forward the email.
Exactly.
Right, but I don't have a reasonable expectation that if I put something on the web generally, that it's not out there for anybody in the world to get instantaneously.
Right, and I think that that would be true for information that someone had designated as public. But what we're talking about here is information that maybe has been designated as friends only. I think that there's a difference there. The user has made a choice to limit the privacy of this information to only their friends. They've been told throughout every other piece of information on Facebook's website that it's friends only, it's not public, it's much more limited, you have control over that.
Right, I get that, but I mean, I think your focus on the notion of email requiring forwarding is less persuasive to me without, I mean, unless I, if I read the rest of that, which says elsewhere on the web, and I know that that means that once I post something, it's potentially available without any further action. I mean, that's how I see when I post things on the web, maybe not email. So I mean, I'm just,
Right, and I just understand the concern. The way that I read that sentence and the way I think a reasonable user could read that sentence, which is really all we have to say, is that when you say elsewhere on the web, you're talking about something you've publicly posted on the web. And I think that there's a distinction between information designated as public and information designated friends only. And that sentence, that clause really speaks to public information. And again, is kind of reinforcing the idea that applications might have access to your public information, but not information that you have designated as private for your friends only. And again, I think it implies an affirmative step. I think if you look at the next paragraph of that, I'm looking at 2220 here. It talks about this is necessary to make apps social and more personalized. That also implies that maybe it's only applications that you mutually use together. That, if we both download Words with Friends and we're friends on Facebook, that Words with Friends will have the information that we share with each other, but not if you download an application that I've never heard of. My information will suddenly be swept out to that application that I know nothing about, and I have no notice that you've done that. And that application can use the data for whatever it wants.
so what about the disclaimer or the notification? And I think it only appeared in 2011, and we can get to the timing questions. But remember, the people you share with can always share your information with others, including apps. And your argument would be that still implies that it would require some affirmative step by the friend.
Right, and I think that's because it's consistent with this kind of intuitive notion that we've talked about before, that if I share something with you like an email or a letter or a physical document or something, that you can make a photocopy of it and share it if you want to, but you're making a choice about that particular document and you're deciding, this particular document is going to get shared. I think that's just really different than the sweeping amount of data that was collected by applications in this case, which had very little notice, was not clearly disclosed, and it was a huge part of what made Facebook a successful business. I mean, you look at the testimony from Mark Zuckerberg about this, about all the Facebook witnesses about this, and they say this was a really critical part of what made Facebook a successful business, is that all these third parties could build these games. Facebook didn't have to build them. People would use them, and they would use it through Facebook. So it's like a real centerpiece of the business model, and they're not telling people about it in a clear way. Maybe they have some, vague disclosures sprinkled throughout a couple of documents that sort of hint at this idea, but it's really nothing like a clear disclosure. And I think if you compare that to the statements that were at issue in the Earth Island case, which were very general, did not make very many promises about anything, this is really much more of an egregious example of something that would be misleading to a user. So I think that kind of covers the friend sharing basis, and I'm happy to move on to kind of the enforcement theory, which is our second bucket of misleading statements. And I think, Earth Island speaks directly to this about when a company has given an impression and they're really taking little or negligible steps toward achieving those goals. What Facebook told users is that we require applications to respect your privacy. That implies that they're doing something to require that, that they can delete data from applications, that they can audit.
They did do one thing to require it, is they made it a condition of the agreements they entered into with their terms of service and related documents in connection with what applicants would do. So they did do one thing. Your view is it implies they would do more than that.
Yes, I think it implies it would do more than that. And I think we also have substantial evidence of Facebook learning about third-party applications violating those terms of service. Cambridge Analytica is just one example of them, but there are several others in the sealed portion of the record where Facebook knew that an application broke its terms and it did not do anything. It did not ask the application to delete data. It did not delete the application from Facebook. It just allowed the misconduct to continue. And so any, I think, reasonable reading of we require applications to respect your data means that when you become aware of a violation, you'll actually take some sort of action in response. And I think it's really misleading to users.
And there too, they did take some actions. You just think they were so insufficient as to make their general statements misleading, at least sufficiently arguably misleading to get to a jury. But they at one point they directed for return of the or destruction of the data, right? So they did take a step.
In the Cambridge Analytica case, they did take that small step, but there are other examples where they took no steps at all.
I mean, so those are the ones that were discovered as having breached whatever protocols were in place by Facebook. There's obviously no way to know. I mean, one, there may be a way to know, but I don't think there's any evidence in the record of actual enforcement actions that were taken, although there's a reference in Facebook's brief. But there's obviously no way to know how many third-party apps simply chose not to engage in this conduct because of Facebook's enforcement policy, right? So the anecdotal evidence of however many breaches occurred doesn't really tell us that much about how effective their enforcement, not just their, I know we're using enforcement broadly, but the enforcement policy, but as well as just the rules were, right?
I think that's fair. I think that the representation that we require applications to respect their privacy encompasses more than just kind of setting out some rules and then having no enforcement mechanism whatsoever. So I take your point that we don't really know how many just kind of voluntarily complied, but we do know that some didn't comply and that when Facebook learned about that, it didn't do anything. So I think that's part of the misrepresentation there. And I think that we also know from the Cambridge Analytica example is that some applications told Facebook in the terms that they told users that they were going to violate the policies and they were allowed to operate anyway because Facebook didn't read the terms of service of the application. So Alexander Kogan's application said, I plan to collect user data and I plan to sell it commercially. That is a clear violation of Facebook's rules, and it was allowed to operate for several years on Facebook's platform. So I think even if you're talking about like how many people complied from the get-go, there really wasn't anything that would stop an application from violating the rules without consequence. And I think that's really where the misrepresentation comes. And then I think the other part of this is the statement that applications are only allowed to use or allowed to see data for certain purposes. And in the consumer case from the Northern District of California, it said a reasonable user could read that and think, oh, there's some sort of technological tool here that stops the data from being used in a particular way. And that would be a reasonable reading. And so I think once you have that, we get past summary judgment on that point as well. Unless there's more questions on the enforcement theory, I think I'd like to move last to the omission of the Cambridge Analytica data leak itself. The omission from Facebook, once it learned concretely in 2015, if not earlier, that Cambridge Analytica had taken the data of 87 million Americans and used it improperly. And just the decision not to tell users about that is a clear omission under the CPPA. Saucier tells us that you don't need any affirmative duty to disclose, but I think even if you kind of want to think about it in terms of Facebook's representations, their representations were enough that they should have had to comply with that. And if you look at the securities case from the Ninth Circuit also about these, it says the failure to disclose that even if they had disclosed the risk that this could have happened, once they knew it had happened, they were under an obligation to disclose that to users. And that was a material.
Or was that
omission.
investors? Was that?
So that's the securities.
Right. So I thought they were saying there was an obligation to disclose that to investors.
Yes, to
Not
investors,
users.
sorry. But I think it's the same analysis here, right? Because the reason you have to disclose it to investors is because it's important for evaluating the price of Facebook stock. And I think it's equally, if not more important, for evaluating whether as a user I want to use this service at all. or if I want to take some other affirmative steps to protect my data now that I know that this risk has materialized. And so I think for the exact same reasons, it would be material omission here. And speaking about materiality, I think Earth Island again emphasizes that this is not a reliance standard. It is a whether a reasonable user would care about this information. I think there's overwhelming evidence of materiality here. I mean, you have the public reaction to the Cambridge Analytica data leak. You have Facebook's own internal statements once it became public about how huge this was for the company, the effect on the stock price, the hundreds of thousands of users who deleted their Facebook accounts when they learned about this. You have statements from their own witnesses. The 30B6 witness, Allison Hendricks at 2751 says this was an enormous problem for Facebook. And we knew that people wanted control over their data. Otherwise, they weren't going to use our service at all. So it's really baked into the business model. So I think there's really no way it couldn't be material. You can certainly get past summary judgment and it goes to the jury on that. Last point I would make on materiality is that they make a point in their brief about how they're the only ones with an expert on materiality. But Mr. Bai's testimony was applying an economic materiality standard, which is whether a user would have made a different choice. And that's not actually what the CPPA requires. That is much more akin to a reliance standard, which Fort Lincoln tells us is no longer kind of a requirement for a CPPA violation. So all you need is to show that this was important to people. And I think that we've met that burden. Also, he didn't look at certain key pieces of information, like how many people deleted Facebook, which I think is a really key evidence of materiality that he ignored. So looking past our affirmative case to the legal errors that we think affect the summary judgment ruling, I think there's a number of factual disputes. I think we highlight 6 of them in our brief alone that were overlooked or where the evidence was, viewed in the light most favorable to Facebook rather than to us. I think on the analysis of the disclosures themselves is really quite limited to this statement was made. It's not technically inaccurate. Therefore, it can't be misleading. And I think that's just totally wrong under the CPPA and under Earth Island in particular. So I don't think there's really any analysis of our evidence of how someone would be misled. On the duty question, the trial court used the word duty many times and said there's no duty here, but I think that's just flat wrong under Saussure, which says you don't need any duty. The CPPA itself creates an affirmative duty to provide truthful information. And lastly, on the burden of proof point, I think the EMD case that we filed a 28K letter about really makes clear that the preponderance is the standard burden of proof. They've provided no logical reason why a different standard would apply in a non-intentional misrepresentation case. The only thing they rely on is a single sentence in the Frankeny decision. I think we've explained why that's not a holding of Frankeny. It wouldn't bind this panel, and it certainly wasn't necessary to the decision. So I think that's just not enough to get them there where they need to go there. So unless the court has any further questions on the summary judgment issue, I'd like to at least briefly discuss the expert. I think the most important cases on this are the Little case, the Jewel case, and the Price v. L'Oreal case. All of those cases allowed an expert to testify on very similar types of opinions that are at issue here, which is what would a reasonable consumer perceive from this advertisement or this statement by this company? And the expert said, well, based on my research, based on my experience, this is what a reasonable consumer would come to. That's exactly what Dr. Schaub was opining about here. They have pointed to no case where that's kind of been something that wouldn't be admissible. And I think his expert report is, I encourage the judges to read it very carefully because it's very thorough. It links all of his opinions to peer-reviewed research about consumer behavior and why those principles from those studies would apply in the case of Facebook's disclosures. And I think that's a very standard method of providing expert testimony in a consumer case like this.
Can I ask you a kind of a framework question? the trial court's analysis seemed to be kind of a yes, no, overall, up, down, the report will come in, the report will not come in, rather than maybe a more granular analysis about whether there are aspects of the report that were adequately supported and aspects that were not. Did you argue, was it argued to the trial court that way, or was there, and do you think it's been briefed in this court in a way that would kind of open up the issue of whether parts might be in and parts might be out, or do you think it really is kind of an overall up-down determination as the matter has been presented to the trial court and to us?
I certainly agree that that's how the trial court viewed it. I think we have explained in our brief, and particularly in the reply brief, about why we think at a minimum certain aspects of it would be allowed in. And I again point to the Price case for that. That was a case where the expert offered two opinions, one of which was about how a reasonable consumer would read a label on a hair product, and the other was whether a reasonable consumer would care about that label. And the court said, well, he can opine about the first thing, which is how a reasonable consumer would read it, but I don't think there's enough support for the second opinion, so I'm going to exclude that. So I don't think we needed to kind of forecast how the court could break up the expert opinion in order for it to get in. I think we provided enough support for the whole thing to get in, but I think the court could say more limited aspects of it stand alone. Particularly, I think that would be true of the readability tests, which are a valid test. They've never argued that they're not. They didn't argue he did them improperly. So I don't see any basis, even from the trial court's own kind of musings at the hearing, about what would make that inadmissible. And I think those kind of provide foundation for his other opinions, which maybe makes it a little difficult to separate them out. But certainly the testing alone and the results of those tests would be admissible expert testimony.
Can I ask you a little about the authority you rely on? I mean, I take it as undisputed that we're reviewing the trial court's ruling here for an abuse of discretion, so it's deferential review. Right?
Yes.
And so, I mean, some of the cases that you point to in your brief as sort of, you say, analogous cases where evidence like this has been admitted, one could say don't really get all the way to what you would need to show, given that the trial court has ruled against you here. What we would need to conclude is that it's an abuse of discretion to exclude evidence, a report that is like this. I think it's fair to say that in some parts of it, it is really, I've read them, I'm an experienced person, I've read them, here's what I think about the extent to which they'd be misleading. Do you have cases that take the form of, that you think are kind of factually comparable to that aspect of the expert's report here, where a court ended up holding, it would typically be an appellate court, I guess, that would be doing this, that would be saying the trial court excluded this, but really it's not just that trial courts can let this in or not let this in, it's that really they're required to let evidence of this kind in. Do you have cases that take that form?
I don't think we have cases in that particular posture, but I think if you read the Jewell and Price cases in particular, the court doesn't really frame its opinions as this is in because it's kind of within the discretion of the trial court judge. They're framed really as under a proper application of 702, this would be admissible expert testimony. So I recognize the distinction you're drawing, Your Honor, but I think those cases give us enough support, even given the difference in the procedural posture. And I think if you're kind of applying the abuse of discretion lens, really what you have here is a single sentence order that says, for the reasons stated in the opposition, and we can fight about the weight of that Scrivener's error, and the reasons stated in open court, I'm striking the expert in its entirety. And I think the problem that Facebook has there in kind of trying to reconstruct what that order means is that several of the things said at that hearing are actually inconsistent with the things they said in their motion. So things like the reliability tests, their main objection was, the readability test was, he applied that test to the entire disclosure rather than the specific portions we think are relevant. And the trial court said, I don't understand that argument. And so obviously wasn't accepting it, but then the ruling itself, they're trying to say, well, it adopted our theories. So I think there's some problems with trying to kind of reconstruct that and give it the full abuse of discretion, deference that you would normally give to a trial court decision, because there's just inconsistencies within its own reasoning. So we've kind of briefed it as this is how the proper application of 702 would be. And I think under that, we really clear the bar easily here because he's making expert opinions that other courts have recognized are valid. They don't have any objections to that we think go to the admissibility rather than the weight of the testimony. And so I think a proper application would be admitting the testimony.
I mean, are you saying there's not enough? Are you saying we can't rely on the trial court's reference to its statements at the hearing? Or that there's not enough in its statements at the hearing to support its 702 exclusion?
I think it's both. I think what Facebook is trying to argue is that, everything the trial court said at the hearing should be construed as a finding, except for all of the findings that are contrary to what their motion said. And I think you can't really have it both ways, because then you're really asking, what did the trial court rely on to decide this issue? So I think those inconsistencies are a problem. And I also think there's not even enough, even if you just look at the parts that seem favorable to Facebook, to say that the testimony should be excluded.
I mean, there was one kind of lengthy statement by the trial court, relatively lengthy statement by the trial court. I think it's transcript or JA volume 1, 973. It said he didn't employ the scientific method. To the extent he deployed one, it's inconsistent with how it's normally done, how it's normally applied in the field. I'm paraphrasing a little bit. It's just a summary of his opinions. There's no indicia of reliability. There's no quality assurance. There's no peer review. I mean,
Right.
that kind of almost checks all the boxes of Daubert. I'm not saying it's right or wrong, but I mean, maybe we would want more as a reviewing court, but I'm not sure it's not enough for us to know what the basis for the opinion was.
So I think that's, a fair point that he says that. There are other parts where he says things that are kind of inconsistent with Facebook's theories, but even just taking kind of that summation that you're referring to, there's no requirement that things be peer reviewed in order for them to be admissible under Daubert. So that's not a real objection under 702.
Let's slow down on that something isn't required for expert testimony to be admitted doesn't mean that it is not a relevant consideration in exercising your discretion about whether to admit it. So I'm not sure that the observation you made is a basis for dismissing that as a legitimate consideration by the trial court in ruling.
So I take that point, Your Honor, but I think what the trial court was saying is that the opinions here were not peer reviewed. And even when courts have said peer review is an important factor, what they're talking about is peer review of the tests or the evidence that the expert is relying on. And that is peer reviewed. All of the things that he is citing are published works. I think most of them are peer reviewed. And a lot of them weren't even written by him. So it's not an instance where I think the peer review really gets you anywhere. In terms of he never did testing of it, their main objection has always been that he didn't do a survey. And I think he has explained in detail why a survey wouldn't be possible given the circumstances of this case. And there are other cases that explicitly say a survey is not necessary to provide this type of testimony. So again, I think that at most gets you to weight, not admissibility. And then I think the rest of the summation is he essentially just provided his own opinion of what these statements mean. And I think that's just wrong. If you look at the expert report itself, he is not providing his own, this is what I read from this statement. He's saying, this is what the studies say a reasonable consumer would take away from this. And I'll give you a concrete example. He says, there's an intuitive, I think we would all understand that if there's headings within a disclosure that suggest I don't need to read that I'll skip over it as I'm kind of deciding what's important for me to read. But there's actual studies that support that that is what normal consumers do. And he cited those and said, I'm applying that, principle based on these studies and surveys to these disclosures. And I'm saying the critical disclosure that Facebook thinks everyone should have read was under a heading about Facebook platform, which a user wouldn't even understand what that was unless they already knew that platform meant third-party applications and that friend sharing was a thing. So he's kind of applying those principles from the research in order to get to his conclusion. So I think everything that the trial court said there, even if you assume that that is a finding and that's the reasoning and it's enough to get to kind of the abuse of discretion standard, I don't think any of it holds up under analysis. So unless the court has any further questions, I'll reserve my non-existent time for rebuttal.
Okay, counsel. We'll hear now from counsel for appellee.
Good morning, Your Honors. May it please the court, Joshua Lipschitz for Facebook. So this case has been going on, went on for 5 years. And throughout those 5 years, the district's theory of the case kept shifting, kept changing. We heard more of that today. Suddenly, the theory of the case on friend sharing seems to have shifted again. They're no longer arguing that friend sharing was not something people were aware of. Now they're making some other distinction about friend sharing. Judge Ross watched the case shift and change over many years. He watched the district try to add new defendants to the case 4 years into the case. He watched them try to amend the complaint 4 years into the case. He watched them try to extend discovery after 4 years of discovery. He watched them try and bring in an expert witness after they had gathered no evidence of misrepresentations through factual discovery. They tried to bring in an expert witness to paper over that lack of evidence with simply an ipse dixit opinion that the expert read the disclosures and found them to be misleading. Judge Ross, after 5 years, rightfully dismissed this case on summary judgment after reviewing all of the evidence, and this court should affirm. Now, on the core theory that Facebook misled consumers about friend sharing, that theory has been rejected by many other courts around the country, including the multi-district litigation in the Northern District of California, including Cook County in Illinois, including the securities litigation case also in the Northern District of California. And the reason for that rejection of that theory over and over and over again is that friend sharing was disclosed over and over again in layered ways, exactly as the FTC said it should be disclosed, in layered ways, in policies, on websites, on the different screens within the Facebook application itself. It was in the Help Center. That's Joint Appendix 257 to 258.
You're speaking quite generally about friend sharing being disclosed. But I feel like we need to get into specifics because part of the district's claim is, sure, there's disclosure that you can share things with friends and your friends could share things with others. But one would not reasonably understand that to mean that by sharing things only with your friends, your data can be scrapped through whatever apps that your friends are also using. You would think it would take some affirmative step on the part of your friend to share your data. That seems like a plausible theory to me.
Your Honor, a few responses to that. One, exactly what Your Honor just said was disclosed. It was disclosed, for example, in the data sharing policy, the data use policy.
Let's just pause because you could say two different things though, right? You could say your friends can share it with others. That could lead you to believe only your friends could share it with others. Even if you later disclose, and also your data could be scrapped by anybody, it doesn't take away the force of the first thing being misleading. I mean, it might mitigate it a little bit, but it's not obvious which one should trump. If we say one misleading thing on page 8 of our disclosures, and then we clarify it on page 72, why can't we say, so what? A reasonable consumer would read page 8 and they'd never make it to page 72, and they would think that only friends could share stuff affirmatively.
Because in this case, page 8 and page 72 say the same thing. They say the same thing over and over again. So if you look at Joint Appendix.
Just abstractly, do you agree that if a merchant, for purposes of the CPPA, communicates a bunch of information to a consumer, and somewhere in there is said A, and somewhere in there is said the opposite of A, that it's not a defense to the fact that A is misleading, that somewhere else the opposite of A was said, even though everything has to be read together. If the best a consumer could do by looking at the documents as a whole would be to say, at some places the person is saying, the merchant is saying one thing and in other places saying another. Do you think that is a defense to misleading, to a CPPA claim on the theory that there were misleading statements? If it was, I know you don't think they were internally contradictory, but I'm just asking the abstract question. What's your analysis of a situation where there are just, at one point the consumer is told the true thing, and at one point the consumer is told a thing that's not true, and they're just flatly inconsistent?
If there's a statement A and a statement not A, and only one of those is true, then that could potentially state a CPPA claim, but that's certainly not what we have here at all. The disclosures here over and over and over again say the same thing, and I would just all I can do is point the court to a few of them, but the court can go and review all of the disclosures that it wants. Joint Appendix 279, people on Facebook who can see your information can bring it with them when they use apps. That's clear as day. And in fact, that's the same disclosure that appeared on the privacy settings page itself. So we hear a lot from the district about how the privacy settings page supposedly allowed you to choose, which it did, friends only, as opposed to posting your information to the public. But the privacy settings page on JA 224, 281 to 82 also told users that, quote, the people you share with can always share your information with others, including apps. Why the district keeps saying that the privacy settings page doesn't say anything about apps is beyond me. It's right there. As I said, JA 224, 281 to 82. Now, as to the question of whether friends took some affirmative step to then share your information with apps, they did. The friends make a decision, an affirmative decision, to download a third-party app and use that app and agree to that app's terms of service. And in this case, the terms of service actually allowed took information from users about the user's friends. This was all disclosed. It was all disclosed that your friends could share your information, and that's what friends did here.
Do you agree or disagree with the instinctive reaction I have that to the extent someone might take away from some of the statements, which I know you may not agree with, but imagine that from some of the statements, a user could think, okay, this information that I'm sharing with friends could be shared by my friends if they make a conscious, intentional decision to share my information with others. The process you describe by which there are affirmative actions by the friends to download an app that has legal, that where there are terms of services that if the friend reads, the friend might realize means that there is automatic sharing of the original friend's data is a little bit different. And maybe you don't think materially different, but at least it seems arguably different from the image that you might have of, I can share with my friends and my friends might make a conscious, intentional decision to share with others.
I'm not sure why there's a distinction. If you think back at what the core of this case is a question of privacy, right? Was my information shared beyond the people that I expected it to be shared with? We have an admission from the district that once you share information with your friends, that information's gone. It's out of your control. Your friends can do with it what they like. They can take a screenshot. They can post it on the front page of the New York Times. Those were the exact words, I believe, of my colleague just a moment ago. At the point at which that's true, why does it matter how the friends decide to share your information?
I mean, it strikes me like it obviously matters because I don't think my friends are going to do those things. I think my friends might download an app though without reading the terms of service. Like that sounds like an obvious answer. I mean, it just seems like an obvious answer to that. Yeah, I can share information. My wife and my kids have access to my birth certificate and social security. They're in a box somewhere in our house. I suppose they could share them with somebody, but I don't think anybody would. I don't think any of them would. Now, if they clicked a box on an app that said also we can raid your house, and it's somewhere down in the terms of service, it's a fanciful example. Well, I'd say, well, obviously that's not what I had in mind by they could share it with somebody else. I would think they have to affirmatively do it, not just whoopsie daisy. And this seems like they can whoopsie daisy share everything with all their friends without even thinking about any of the degree of data that they're sharing. I mean, they strike me as wildly different.
Well, I guess I would point this court to the district's own expert who said at JA 2071, Facebook makes explicit disclosures about apps' ability to access a user's friend's data. So all we're talking about is access. At the point at which you share information with friends on Facebook, there are others that may have access to that information. That includes your friends' friends, it includes your friends' apps, it includes the games, applications, and websites that your friends use. Not that you mutually use together. That's not at all what the disclosure said. The disclosure said that they can share it with others, games, applications, and websites that they use. So if the question is one of access, as soon as you share information with your friends, there are others that will have access to that information.
Can I ask what your reaction is to the back end evidence that people didn't understand this, namely, the massive hit to Facebook stock, the huge decline in users after the Cambridge Analytica story broke, and why that isn't, pretty good proof that people didn't understand what apps were capable of and were not didn't know what they were agreeing to?
I have a couple of responses to that, Your Honor. First, the information about friend sharing was actually first made public in 2015, not 2017. The Guardian ran extensive articles in 2015 about the concept of friend sharing. In fact, about Cambridge Analytica in particular, getting access to millions of people's data. There was no reaction whatsoever to that news. The stock price didn't move. Nobody quit Facebook. Nobody cared. Now, it is true that 2 years later, when people believed that same information was used to elect President Trump, people suddenly cared, and they may have had their own reasons for caring about Facebook's supposed help in electing President Trump in 2017. But nobody cared in 2015. And in fact,
I Googled while, your counsel was talking when the Cambridge Analytica story broke, and the answer that I got back was 2017, 2018. I mean, it might be that there was a story that came out in 2015 about it that only got to, nuanced tech readers, but it was not a widespread story. I mean, my recollection of it was not that it was widespread in 2015.
In fact, it was, Your Honor. It was reported by the mainstream press, The Guardian. I believe the New York Times picked it up in 2015. It was all about the Senator Ted Cruz campaign. And there was big news about how the Cambridge Analytica had misused Facebook data to help Senator Cruz's campaign. And by and large, nobody cared. Nobody changed their settings. Nobody went to remove the Facebook app. And in fact, it was only what happened in 2017 was not that people found out about friend sharing. That wasn't what happened. In 2017, what we learned is that even though back in 2015, when Facebook learned that Cambridge Analytica had harvested all this data, Facebook went and actually removed the app from their website. So they took more than just small steps. They removed the app, the Cambridge Analytica app, from Facebook. They required Kogan and Cambridge Analytica to sign affidavits affirming that they had deleted all the data. And so from their perspective, no one had reacted. The problem was solved. The data was deleted, and they had certifications agreeing that the data had been deleted. Incident over. Well, it turns out 2 years later in 2017, the New York Times found out that Cambridge Analytica actually hadn't deleted the data. So they had kept the data that they had originally scraped in 2015, and that they used it to ostensibly help elect President Trump. That's the news that came out in 2017. It wasn't about friend sharing. It was about the fact that Cambridge Analytica still had this data that everybody thought had been deleted and used it to help President Trump. That's when the public got very upset. That's when people started investigating Facebook. Lots of attorneys general in states that were not so friendly to President Trump started investigating Facebook.
So that's your argument that your earlier lack of enforcement was material?
There is no materiality to
No,
the
I'm sorry. I was smart. But one thing that you said caught my ear, so I want to go back to it. When you were making an argument about why you don't think there were misrepresentations in connection with what you're calling friend sharing, might be called other things. It's maybe a disputed label. You made a reference to the idea that we should consider or look to the district's own expert. Do you mean the expert that you persuaded the trial court not to consider?
I do mean that expert. I don't mean that this
So we
court
can't,
should.
it's not really in front of us as something we should be considering. Unless I guess we ruled against you on the exclusion.
It was a hypothetical. In case the court rules against us, I would point the court to the concession that the expert made about friend
But
sharing.
if you agree that if that remained, if we were to affirm the exclusion of that aspect of that expert's report, we shouldn't rely on it in considering the materiality,
Absolutely.
misrepresentations or lack thereof.
That's correct, Your Honor. And you wouldn't need to. There's ample evidence. In fact, there was a study done in 2015 by the Center for Plain Language, which evaluated the privacy policies of 7 major companies, including Facebook, Google, and Twitter. And it called the organization and navigability of Facebook's privacy policies, quote, exceptional. It said it was the most visually appealing privacy statement it had ever seen. And it concluded that Facebook did, quote, a good job of communicating their privacy policies in a way that allows consumers to understand and make decisions. That's at Joint Appendix 342. So you don't need the concession by Facebook's expert. There's ample evidence in the record that shows both the disclosures themselves, how clear and layered they were. They appeared everywhere. And we'll get to readability and all of that, but the disclosures were all over the place. And you have independent bodies, independent experts who were looking at the disclosures at the time who called them first rate, exceptional.
Can I ask you, I think you acknowledged the abstract idea that a document, a set of information provided by a merchant to customers could be misleading if some places it said a true thing and some places it said the opposite, false thing. What's your view, again, about an abstract question? I know you won't think that this abstract question applies to the documents that are at issue here, but to the abstract question of to what extent, if you think in some places a document says a true thing, and in other places a document at least says statements that considered in isolation would mislead you to think something different. It's kind of puzzling to me how to analyze a case like that in the abstract, because you're supposed to read documents as a whole, or the information as a whole. And so you could say, well, here are some things that in isolation were misleading, but I can go to a different place and that would be clarified. And so I should conclude that, as a matter of law, no reasonable fact finder could find the material as a whole to be misleading. So I can see that line of thinking, but I can see a contrary line of thinking, which would be if the documents are extensive, and sometimes they're misleading statements in isolation, And sometimes there are statements that if you find them would clarify, or if they were viewed as trumping or would fix the problem. You could think, well, I'm not really sure how reasonable consumers would work their way through such materials.
Right.
Do you think that a case like that in principle can be made out abstractly, or do you think if instead of direct, one thing is said and the exact opposite is said, if instead the complaint is there are a bunch of misleading things in isolation, and it may be true that here or there is something that would have clarified if a consumer happened to find it, but the documents are extensive. If that is the case, is that do you think that's just intrinsically fails as a CPPA misleading statement claim, or do you think it would depend on more detail than my hypothetical is
I
providing?
think it depends on a lot more detail, Your Honor. I think it would
But
depend.
you're not arguing that in principle, that's not a possible kind of claim to make?
No,
you
I
don't-
guess I'm
you
not,
were
I'm not
saying-
taking an absolute position on it
Right.
because I think it depends on the circumstances. I think even this court's Earth Island decision, talks about looking at the mosaic, looking at the evidence, the disclosures as a whole, what's out there, what's available to users. There is language talking about not cherry picking language from here or there, from, a particular place, and looking at all the language.
Right, and that's why I was
But
just wondering how
that's
far you take
not
that. I was
right.
just wondering how far you take that.
Exactly, but the cherry picking point, that's not what this case is about at all, because the district doesn't point to a single statement anywhere on Facebook's disclosures that was actually inaccurate.
Well, do you think it's relevant, part of the relevant pieces of information is sort of this contractual notion of users agreeing that they've read everything? I mean, I realize CPAPA is a statute, we don't import necessarily assumption of risk and contract principles into it, but you can draw a distinction between this type of case and sort of the cough medicine on the shelf case where we've said the consumer we don't expect that the consumer or assume that the consumer has read the back of the label. What role are you giving to the fact that users have to agree that they've read sort of everything that's before them?
It's a very important fact in this case, Your Honor. In fact, every court that has thrown out friend sharing, all the ones I mentioned, pointed as a data point, not as maybe the dispositive data point, but
But
certainly
those
as a
aren't, I mean,
relevant
but those
data
weren't CPPA cases, right? Or
No, they
equivalent
weren't.
cases.
That's correct. But they were, in some cases, consumer protection. The Cook County case was a similar consumer protection case. And they said, look, when you sign up for Facebook, you agree affirmatively to the Statement of Rights and Responsibilities, the SRR. You agree not only that you've read it, but you agree to the terms. You also agree that you've read at that point the data use policy, which goes in detail about all the things that we've talked about and discloses friend sharing in great detail. My point is simply that here, this isn't a front label case being disputed or contradicted by a back label fine print. The front label, the back label, the fine print, they all say the same thing here. The contract says that there can be friend sharing. The data use policy says that there will be friend sharing. And then on top of all that, you go onto the site itself. If you're somebody who cares about privacy, there's a whole materiality component to this case too. If you are someone who actually makes decisions based on privacy policies or based on how your information is going to use, it is certainly more than reasonable to expect that those consumers who actually care about these things will go to a place called the privacy settings, go take the privacy tour, go to the help center. This was everywhere you could look. If you cared about this issue, this disclosure appeared over and over and over again.
Although, some of your line of thinking there depends on our agreeing with your view that saying that, friend sharing is possible is the same thing as saying, by the way, any app that your friends, if you've shared information with friends, any app that your friends download can automatically, as long as your friends have agreed to terms of service that permit this, get access to a bunch of your information that you haven't made public. You're saying those things are the same. And, it's.
I'm saying that it's a
the point you're
distinction.
making right now depends on our agreeing with you that those things are essentially the same.
Well, I'm saying it's a distinction without a difference, right?
Right. But if we don't agree with that point, then the point you're making, which is everywhere you look, you see what you need, what a consumer would need, is less persuasive. If you look to the first place and it says, well, you have a box you can check and it says friends only. If you're saying, and then if you look somewhere else, it says you can share with friends. If one were to think, at least a reasonable fact finder could view that as different from, by the way, your friends, if you've shared with friends, those friends, if they download apps, and the terms of service permitted, the apps will have access to your information. If those are different, then it's not accurate to say that everywhere you look, you see the same thing.
Well, I guess
Instead,
I'm-
it's something different. So
I guess I'm
it's not
struggling-
circular is my point.
Well, I guess I'm struggling with that distinction. First of all, because it's new. We haven't really heard that distinction before. But it's also the disclosures that are all over this record. They don't say anything about quote automatic sharing, or it will only be shared in this way or that way. They simply say over and over again that anything you share with your friends can be reshared, that the apps can see it, the games can see it, the applications can see it. So I guess I'm struggling with the distinction because there is no such distinction drawn in any of the disclosures. The disclosures are clear in a blanket way that once you share with friends, the information is out there. It can be shared by your friends with anyone. And in fact, as I pointed to JA 279, people on Facebook who can see your information can bring it with them when they use apps. Just by using apps, it is nothing. It doesn't say
No,
anything.
it doesn't say
about
just
that.
by using apps. It says they can bring it with them when they use apps, which could connote an affirmative choice to share your information when using those apps, rather than automatic sharing by downloading the app.
Well, I guess I just go back to the fact that this wasn't automatic. This was a decision that friends made to use certain apps. The Facebook terms of service.
Right. I suppose, you know, this is piggybacking on Judge McLeese's point, though. It strikes me that there's a pretty big delta between my friends could choose to share my information with somebody sort of affirmatively. Like if they ask, you know, what about Josh's birthday? They could punch that in. They could punch in my phone number and what is he like? And they could go and punch, but they're not going to do any of that. So I'm not too worried about my friends sharing my information. It seems quite strikingly different to say, you know, including by downloading an app and agreeing to the terms of service, that app could then scrape all the data about you and what you've liked over the course of your history. I mean, they just sound wildly different, like wildly different things to me. I mean, I appreciate maybe they don't to you. I mean, I think in today's day and age, I think it's probably more fair to say in 2025, I'm probably more aware that that's what statements like that mean. I would now sort of understand data scraping. Those terms were not really, you know, maybe in your profession they were, but they were not such common parlance in 2015 in terms of like the ability of just how much data they could grab off of a page. It strikes me as non-obvious to reasonable consumers that reasonable consumers could adopt the district's view of the statements at issue, that they thought it meant an affirmative choice to take a step to actively share your data beyond just downloading an app. I don't know. I mean, it sound like the kind of things that we would normally leave to a jury.
I guess one point in response is that just as a technical matter, this is not a data scraping case, and I know Your Honor doesn't mean it the way that I'm about to describe. It's not.
I don't know what it means technically. So go ahead. No,
So this
tell
was
me.
an actual data sharing case, right? So data scraping is when a website or an app just goes around the web and just tries to find information wherever it can find it and pulls. This was actually an affirmative decision by users to download an app and use an app, right? So
you tell me technically, it will show how ignorant I am. But so I am a user of Facebook. I have a friend, both counterfactual probably, but and I I've picked friends only as my sharing of information, and my friend downloads an app, the terms of service of which say, if by agreeing, I don't know, but hypothetically, to correct me if this is absurd, but you know, the terms of service say, by the way, you're consenting to share the information that we can get from you, which will include information from your friends.
Right.
Like technically, where is data resident? That is, when the app ends up getting my information, is it only dealing with information that has already moved from me and is resident somewhere connected to my friend, or is it going to a place that is the same data that is the storage of my information? Where is it? That may be absurdly.
This may be beyond all of our technical.
I mean, it may be an incomprehensible question.
No, I would say it's only the data that you've agreed to. So if you have
No, but
data
I'm just
on
asking, like,
technically, where is it resident?
Where is it?
We know from this case that Kogan actually was able to, I believe.
Right, but when he gets it.
He actually got some.
Right, when they get it, are they getting it from a place where Facebook has stored it for me, or Facebook has stored it for my friend because my friend and I were friends?
I don't want to represent that I know the exact technical
I'm not even
answer
sure
to
it's
that.
intelligible questions.
No, it may be, Your Honor. I don't.
But I was just wondering, you were saying it's not like it was information that was shared by the friend.
Right.
when I started trying to think of that concretely, I was sort of thinking my friend has my information now because we're friends and I had information and I knew my information could be shared by my friend.
My
I didn't
understanding,
know I
Your
like
Honor-
passed it to my friend and my friend is holding it
Exactly.
in his little, in his or her little information sphere.
Right.
And then if the app takes it, it's really taking it from my friend's
Well,
place
that's,
rather than from my place.
that's
because
my
when you get there,
understanding.
I just don't know how to
Yeah.
conceptualize where they're getting it from, whether they're getting it, they're running all the way back to me to get it, or whether they're getting it from my friend. I just don't know.
My understanding is that the app essentially stands in the shoes of your friend, right? So once the friend agrees to share information with the app essentially stands in the shoes of.
Which means that
They
then it
can see
pretends
what
it's
the
my
friend
friend
can
and
see-
comes and gets
can
my
see what the
information.
fr- it's
Is
not
it
that-
fair to describe that as it pretends it's my friend? and
No,
comes and gets
no,
my information?
no, it is not. No, it's not fair. to
Because I mean,
describe.
if Judge McLeese hasn't, the third party app can't get what Judge McLeese did not share
That's correct.
with his friend. So it
That's
can't be, I mean, I don't mean to be answering a question as a panel member, but
Oh, no, we can't get all of it, obviously. I agree
Right.
with that, but anyway.
It's only the information that you've already agreed to share with your friend, knowing that your friend could reshare it elsewhere. By the way, there is another point that I should have mentioned earlier that I will mention now,
Actually,
which
before
is,
we run off that, just to make, when I agree to share information with my friend, does that mean by agreeing to that, I then send it all to my friend, so my friend has it all right then? Or does it mean we're friends, so you can come look at my information where I have it, and I've shared it with you in the sense of making it making it available. It's like if I share something with you, I could mean either I'm giving it to you right now and now you have it, or it could mean I'm sharing it with you in the sense that you can come and get it if you want it.
so
Do you
remember,
know the
these
answer
are,
to which that is?
remember, these are all just settings, right? So every time you post something to Facebook, you get to decide how restrictive the setting is on that piece of information. Is it available to everyone in the world, or is it available only to my friends? Or there's even a setting to have it available to no one. It could be private information that you post and make available to no one. So it's just a setting. It's not like the information is actually going to your friend. It's available to your friend,
Right,
right?
but
So if
then, so
you,
my information, once my friend wants to actually find it, then I would think in a very childish way in which I'm doing this. My friend would have to ask Facebook to go to my information and get the information that I've shared in the sense of making available. That's why I was asking, like, when I share it, I'm not like downloading it, it hasn't moved from me to my friend.
you're not
It's just my friend
downloading
has
it.
access to
The
it.
friend is certainly not downloading it. I think there's a
Right.
question as to whether Kogan actually extracted
Anyway,
data, but that.
So I probably derailed us on that.
No,
Far longer than I ought to have.
That's fine, Your Honor. It's confusing, I confess. The point I was going to make, though, Your Honor, to your point is there's another setting that we haven't talked about, which is the application settings itself. So on the privacy settings page, the privacy settings page tells users that the people you share with can always share your information with others, including apps. It then points you to the app settings where you, as a user, if you don't want apps getting information from your friends, you can simply turn off that feature altogether. You can actually make an affirmative decision to say, I don't want apps getting any of my information.
And the way you turn that off is by not using apps.
That's right. You turn off platform. You
So
turn
it's
off
not like
platform.
you can use apps, which may or be relevant or may not be, but you're making it sound as though I have an option, which is I love these apps, but I'm going to just make sure that it's not going to be shared. It's if you don't
Well-
want that to happen, you say, don't use apps.
It depends on the time period. So there are time periods where you could select app by app,
Right.
which is the case now. There are time period, friend sharing is not on the platform anymore, but at the time there were different time periods, right? So at one time it was you had to opt out of platform altogether, then it became app by app. Now there's no friend sharing at all on the platform.
If you want to wind up on friend sharing and move on to, you have a sensor to, but I think we need to.
Yeah, let me just move on if I could, Your Honor, because there's a lot to get to, obviously. And I want to take this court's questions on any of these. But if we look at the enforcement argument, that this notion that Facebook didn't have robust enforcement tools or didn't use them, that's simply not the case. First of all, Facebook repeatedly told users that it is not responsible for the actions of third parties.
Can I ask you about that statement?
Yeah.
Because I know it's to its credit, it's in all caps.
It is.
But I had some questions about it. So the statement is Facebook is not responsible for the actions ... of third parties.
Yes.
That seems like, taken as a statement, it seems obviously false.
Well, it comes in context, Your Honor. It comes in the context of the data use. That's from the data
Well,
use.
just mean generally, I mean, you're saying you think it would be true that no matter what third parties did with respect to data use, Facebook is never legally responsible for it. As long as the third party did it, Facebook is never legally responsible.
I
I
think
think that can't be true.
what Facebook is telling users there is that Facebook, for all the reasons that Facebook
I'm
says
just taking it
elsewhere,
literally for a minute.
I think it is true that Facebook is not responsible for the actions of third parties. I think that's,
So let's say the third party is someone Facebook is unlawfully conspiring with to do some criminal act. Like it would
Well-
depend on the relationship between the third parties and Facebook. It seems like it's an overbroad, untrue denial of responsibility, which legal responsibility, which might, maybe sometimes Facebook would be, sometimes it wouldn't be. Facebook can't make it true by saying it.
well, I think for purposes of the CPPA, I think the question is, what information are you conveying to consumers, to users? And what the information that Facebook is conveying here and elsewhere, when it says that what apps do with data is subject to their own terms and policies, not controlled by Facebook, in the context of where these appear, is that
Again, I
Facebook
was
can't
just kind of
control
taking
the
it
data.
literally and
Right.
wondering how much to give it. So, to get to a real world example that's analogous, I think, to some points the district has made. If I, run a business on a property and I put up a sign that says, I'm not responsible for the actions of third parties on my property. You would agree. I mean, that might do that might have certain legal effects, but taken as an actual assertion, it's just not true.
Whether it's
You
true or
can't-
not, it tells people to beware. It tells people not to look to me
But
to what
would you
might
agree
happen by
that
third
in that
parties.
hypothetical, that just can't, that's not an accurate, that's a legal statement that is not accurate. It's overbroad. It's not accurate. It can't be true that if I own a business, it's flatly, I am never legally responsible for anything a third party does on my premises. That can't be a true statement of law.
I don't, well, first of all, I don't think this talks about legal responsibility necessarily, but I
Well,
think
do you think it
the
was
point
about
is,
moral responsibility or what?
no,
do you
I think
it was
it's a
about?
question of control, right? It's a question of control. Who are you going to look to? Who are you looking to control your data? And once your data leaves Facebook, Facebook cannot, by definition, control everything that third parties do with the data, right? And that's spelled out JA 266 to 267. And by the way, Facebook had policies in place to do the best it could, right? It did require as part of the
It's
policies.
just like the best it could. So if it was doing the best it could, how could it have approved the application, Mr. Kogan's application, which expressly is alleged to have had an express statement that there was an intent to violate the terms of service?
Well, because for a number of reasons. One, there are literally tens of millions of apps on the platform. And so ability to actually read through every single terms of service is not a reasonable expectation of Facebook. But if you look at the enforcement program.
You mean that you think no reasonable consumer could have thought that Facebook was evaluating whether the apps were just, apps everywhere were just stealing everybody's information on
because
Facebook?
The terms of service that Facebook had with the platform, with the application itself, prohibited that conduct. So there would be even if the application wanted to do certain things with
I
data.
was just sort of taking Facebook did the best it could, and then I was putting it through the prism of what a reasonable consumer might think Facebook could do. And, a reasonable consumer might not have any idea how many apps there are, how much how many resources Facebook devotes to making sure that apps aren't stealing users' data.
That's
They
right.
don't know much about any of that, but they might have some beliefs about it, as your opponent argues, from statements saying we take your privacy seriously and
Sure.
we require this and we don't allow that, which certainly could engender generalized beliefs about security and efforts that were going to be made to protect data.
Right. And my point is simply that the district posits that Facebook essentially did nothing to enforce its policies and it had no enforcement program. And that's simply not the case. It had policies. It had a contract with the apps that specifically said it was not allowed to use data in this way. And if your honors look at JA 311 to 329, there's extensive discussion about all of the things that Facebook did to try as best it could to enforce those policies against tens of millions of apps. When there's a sign that says speed limit 55, we know as reasonable consumers that some people are going to go faster than 55, and the district does the best it can to enforce those speed laws and try to get people to comply with them. Facebook had a pretty good track record on this, by the way, tens of billions of apps. We don't see the district pointing to all kinds of evidence of data misuse happening. Cambridge Analytica is one example where an app misused Facebook's data. Facebook immediately took action against Cambridge Analytica, requiring the app to be removed from the platform, requiring the owners of the app to sign affidavits that they would delete delete all the data. There were extensive actions taken here by Facebook to enforce its policies in one of the only examples that anybody's been able to point to of a situation where one of tens of millions of apps actually violated Facebook's policies. So actually the enforcement rubric was both robust and quite effective. And I think there's really no evidence to the contrary whatsoever in the record. And again, I would just point to JA 311 to 329, which describes in great detail, some of which is sealed, the enforcement program that Facebook had in place. And it was both manual tools, automatic tools, software-based tools. They had entire teams of people that looked for violations, and they took actions where they found out that there were violations. So there's really no evidence whatsoever in the record to support a theory of misleading based on this notion that Facebook can enforce, which is what the disclosures actually said, or that Facebook was going to try to enforce these policies. Facebook absolutely did try to enforce these policies. No evidence to the contrary.
Well, you say no evidence to the contrary, but earlier you acknowledged that there were so many apps that Facebook wasn't even reviewing them to determine whether on their face they were inconsistent with Facebook's requirements.
No,
That seems contrary to a no evidence
No,
assertion.
if I said that, I misspoke. My point was simply that there were a lot of tools available to Facebook, not simply reading through the terms of service of every app. There were software programs that could do that. There were enforcement teams that would try to find violations. There were, and again, it's all detailed in the sealed record, but
Well, even if you're just taking it literally, your assertion there's no evidence of inadequacies of enforcement, this case isn't, you would have, this is what you think inadequate means, but there were some, what you might think a consumer would reasonably view as weaknesses in the enforcement. If an application submits a, whatever the, a contractual proposed, I don't know what the right terms are, but if Mr. Kogan submits an application to be admitted to this program and on his face it says, I'm going to sell information that the terms of service prohibit him from doing, and that's not caught, that is a problem in enforcement. You would agree, or you don't think so?
I don't think so, because that same Mr. Kogan also agreed to Facebook's policy, Facebook's contract that said that he would not do those things. So it's perfectly reasonable enforcement to have a contract between Facebook and Mr. Kogan that says he will not misuse data and rely on that contractual promise. Whatever Mr. Kogan's intentions are, there's a
Just make sure I
contract between
understand.
Kogan and
The
Facebook.
theory is it's perfectly good enforcement to, if you have a term that is in the contract that precludes something, not review the contract to see whether the person who is entering into the contract is saying, I intend to do the opposite of that.
My point is that Facebook had an express contract with Mr. Kogan through the terms of the platform that prevented Mr. Kogan from doing those things. Facebook's disclosures to
And by
users
prevent, you mean legally prohibited him.
legally prohibited by contract, yes. And Facebook's disclosures to users simply said, we can enforce against apps. We can. They use the word can over and over again. It never says, no reasonable consumer could expect that Facebook would catch every violation of those or would enforce against every violation of those. It's not a reasonable, that simply wouldn't be a reasonable reading of Facebook's repeated language. We can enforce, we can use our tools. We have tools available to us. All of that is true. And in fact, in this case, those tools were utilized quite effectively, other than it turned out 2 years later that the certifications of deletion ended up being subsequent lies.
Well,
to
quite
Facebook.
ineffectively at the front end in agreeing to an application that said on its face, I'm going to violate the terms of service.
Well,
That
but
seems
not
like
where that same
ineffective.
application.
Again, nothing is perfect. So you could say it's not unreasonably ineffective, but that's a defect in what happened. If you wouldn't want to have your system operate where you enter into agreements with people who say, we plan to do something that you are telling consumers you value not having done, and that, we're telling consumers we're requiring people not to do that. That seems,
I guess
that's a defect in it. You don't think that's
I guess I wouldn't call that ineffective where I have my own contract with the person
Well,
saying that they won't do it.
Factually, I'm confused about what the allegation is that Mr. Kogan admitted that he was going to do that was not caught by Facebook.
I guess the allegation, as I understand it, is that Kogan had terms of service associated with his own app that said he was going to, that part of the app was to harvest and utilize and potentially even sell data to others. But Facebook, when Kogan signed up the app on the Facebook platform, Kogan agreed to Facebook's terms, and Facebook said you can't do
Well,
that.
let me make sure I understand. And I'm not entirely clear exactly which document this was set in and how it was made available, if at all, to Facebook at the time Facebook was deciding whether or not to approve this app as part of the program. I had the impression, correct me if I'm wrong, that there were statements made in materials that Mr. Kogan submitted to Facebook in connection with the effort to be approved into the program that indicated there was an intent to commercially harvest information. That's not your understanding?
I'm only pausing because you said submitted to Facebook. I don't know. I don't know that they were submitted to Facebook. I think the allegation was that that Kogan had terms of service associated with his own app that talked about a desire to sell information. But when Facebook again, Facebook relies on its own terms of service with the apps, right? So it has terms of service that apps have to agree to when they join the Facebook platform.
So you're not sure whether whatever communication Mr. Kogan made to Facebook to say, hey, I'm Mr. Kogan and I'd like to be part of this program, whether that included an acknowledgement that part of the plan was to harvest information and sell it commercially? You're not sure.
I don't know about that, but what I do know, I don't know, but what I do know is that that Kogan expressly agreed not to do that.
I do know that as well. That's a related but distinct point.
Yes.
I do know that.
Yes. On the question of materiality, there is no evidence here. And again, I want to bring the court's attention to the Floyd case, Floyd versus Bank of America in 2013, where the court explained what materiality means. And contrary to what my friend said a few moments ago, or I guess quite more than a few moments ago, a significant number, it means that the district had an obligation to prove, or has an obligation to prove, that, quote, a significant number of unsophisticated consumers would find the information important in determining a course of action. So this isn't materiality in the abstract. Do I think it's interesting? Am I interested in privacy as an abstract concept? Would I find the information relevant in determining my course of action? In other words, would if I had read the disclosures differently, if I had read some artificial disclosures or some counterfactual disclosures that the district thinks would have been better, would I have taken any different actions as a result of that?
I don't necessarily see those two things as the same. If I'm taking something that's important in determining a course of action, I don't think that means it will in fact determine my course of action. So if I'm trying to figure out, so tell me if you think this would be material. Imagine that there was a lot of evidence that consumers of apps, if they, or consumers of, maybe be more abstract, a consumer was, there's a question about whether the failure, a false statement about a particular attribute of a product was or was not material. And if there's a study that says, 90% of consumers said that if they were trying to decide whether to purchase this particular product, the existence or absence of that would be very significant to their determination. Would you say that's not enough to show materiality, because what you need instead is a number about for how many of which it would have led someone who otherwise would have purchased the product to not purchase the product?
I think the best evidence of whether something is material enough to affect your course of action is whether it actually affects your course of action. People can say
that could easily be true, but that's not an answer to my question. I mean, the evidence I was just referring to is not the best evidence. It doesn't mean that it's
I don't
not
think
adequate
it's
evidence.
I don't think it's sufficient for people to simply say this would be important in determining my course of action.
Or very important.
Or very important. I think the question is, was it actually information that was important in determining a course of action? Would a significant number of unsophisticated consumers in fact find the information important in determining a course of action? And we don't have to speculate in this case as to whether that is true or not here, because the only evidence in the record, the only evidence.
So just to, let me just make sure I understand. Imagine that I'm a consumer of an experimental drug, and I am, have a serious disease and I'm expected to die from it. Yeah. And a merchant puts on a disclosure about the drug. It is proven to have no side effects. And it later turns out that it had serious side effects and it led to fatalities and was, that was a wildly false statement. And let's say this is only available to people who are otherwise have a terminal diagnosis. And so people would say, wow, that would be incredibly important to me. At the end of the day, I probably would have done the same thing, because I would run the risk of those side effects to avoid what seems like otherwise certainly passing away from the disease I'm suffering from. You would say not material, because although, obviously, like you would think, critically important to people as they're deciding whether to take a drug or not. It just wouldn't have changed anybody's mind in this particular circumstance because they were just trapped into having to take this product no matter what lies were being told about whether it was safe or effective, whether it was had no serious side effects. Is that
Well, I
seems like the
can't agree with, I can't agree with your characterization because you use the word trapped, but
Yeah,
I don't, no, I think under this court standard in Floyd, the question is whether it's material in the sense of affecting people's course of action.
Well, that's not the wording we used in Floyd.
A significant, the district has to show, quote, a significant number of unsophisticated consumers would find the information important in determining a course of
That's
action.
kind of ambiguous as between the two things we're talking about, I think. Just consider it in isolation and we consider other
Okay.
cases as well, but it seems ambiguous. It's like, it's very important to me in making my determination, but as it turns out in my particular context, it wouldn't have been load bearing and I would have made the same determination. It just seems ambiguous, that language about is it important in determining? Does it mean had an important determining effect? Or does it mean important as I was determining?
Well, and I guess what I would say, Your Honor, is if we look at the evidence that's in the record here, there is no evidence that that these disclosures were important in determining any course of action. And the only evidence on that point is Facebook's expert, which did conduct a series of studies.
But why, again, I always get thrown by phrases like no evidence, because in my childish way, I think like challenge accepted, there has to be at least some. Your opponents point to, for example, general statements by Facebook that it understands that people feel like they need to, control their information. And again, it might depend on this topic we've been discussing about whether you mean, is there evidence that this would actually would have changed people's conduct and they would have not, they either would have, I guess, completely disabled platforms at the time when that was the option, or they would have abandoned Facebook. At other times their options may have been somewhat different. If that's the question, then your assertion may be closer to accurate. But if the question instead is a more generic one of, is there evidence that this kind of topic would be quite salient to people as they were deciding how to use Facebook or whether to use Facebook? Saying there's no evidence strikes me as pretty tough. So maybe that there's a connection between.
I think there's a connection between the different
that's fair.
standards.
That's fair.
So I don't mean to talk past you at all.
No, that's fair.
Judge,
No, that's fair.
I think the point that I'm making is when it comes to materiality, there is a course of action component to that requirement. I think we can all agree that at least the words course of action appear in the Floyd decision. And when it comes to actual evidence of what happened when people found out about this, we know from 2015 when people originally found out that there was no significant steps taken, no price plummet of the stock, no users deactivating Facebook. But we also know from Facebook's evidence, from Facebook's experts, that when Facebook's expert went and conducted user studies on the course of action changes that they would take in response to these kinds of disclosures, there was no statistically significant or significant change in behavior. People did not in significant numbers go in and change their privacy settings. People did not in significant numbers go and delete the Facebook app or stop using Facebook. Ultimately, again, it turned out that there wasn't much to this, that people didn't really care, either because they simply didn't care who was getting the information that they'd already shared with their friends, or because they already knew that by sharing information with their friends, they've lost control of that information. It's gone. It's not information that they're intending to keep just to themselves. Whatever the reason is, we know from the user studies that Facebook's expert conducted that this did not affect behavior. In contrast, we have the district's expert who was excluded, and I'm not saying you should rely on his opinions because you shouldn't rely on them at all. But when the district's expert was asked, did you conduct user studies to look at user behavior? The response was, I could have done that, but I didn't. And when asked why he didn't do it, it was because it would have taken a long time and been expensive. That was the response. And, frankly, in a case that's been pending for 5 years and seeking $1 billion in damages, that's simply not an adequate response to what
You're well over time, so I do want to get you to wind up. I know you haven't talked yet about the expert, and you haven't yet talked about notice, I guess. So those those two boxes at least remain. But good. We'll give you a few more minutes, but just so you know, we're running down.
Yeah, that's fine. I can wrap up on the expert. Yeah, this is abuse of discretion. The notion that the trial judge did not provide good reasons for excluding this expert is simply fanciful. The district says in their own brief that the Superior Court, quote, provided no reasoning and merely asked questions at the hearing. That's just not true. And your honors only have to read the transcript. If you want to go to one page of the transcript, go to page 56, JA 956, where Judge Ross lays out in quite significant detail, not questions, but all of the reasons why he is considering excluding the expert, and then ultimately he does. He says, I feel like this is a guy who didn't employ a scientific method. To the extent he deployed one, it was inconsistent with how he normally does it, how it's applied in the field. There's no precedent for what he did. There's no indicia of reliability. It's just a summary of his opinions. To the extent that he did a content analysis, it's misapplied because it's usually done in the field to come up with a code book, to do a study. And there may be other methods, but here there was no method.
Is it your view that all of that applied to everything in the expert's report?
Everything, Your Honor, everything, because the judge even said, I read the expert's conclusions, and then I went to go find the section of the expert report where he talked about his methodology, how he reached the conclusions. And there was no such section. It didn't exist.
What about the readability portion that your opponent focuses on?
The readability, he ran Facebook's policies in their
But
entire.
what the trial court said, I'm not sure that the comments you've just quoted from the trial court are any of them apply to readability.
Well, they
There
do,
may be
Your
other
Honor.
grounds that haven't been mentioned yet, but do those comments relate to?
I think they do
readability?
because he simply used an app, ironically, called readability.com or something like that. He never established that there's any reliability of that app. So he didn't, even as applied to that outsourced app that he used, he did not take any of the steps that an expert would normally take to show the reliability of that app or show the methodology being used by that app. And then he ran the entire policies through the app and said that they're not readable enough. And if you look at the reasons why it came out as with a bad readability score, the number one reason was the length of the document. But of course, the length of the document has nothing to do with when you get to the disclosures at issue, which are only, a few relevant sentences that somebody who's interested in privacy would go to and look at. Not to mention, he didn't run any of the screenshots, the privacy settings, the help center. He didn't do any of that or put any of that through the readability analysis.
So let me ask you the flip of what I asked your colleague on the other side. If we disagree with you on the admissibility of the expert report, do you think this was enough to get to a jury?
Absolutely not, Your Honor. First and foremost, because of materiality. The expert doesn't do anything on materiality. In fact, didn't even try, said it would be too expensive for him to try to look at materiality. But even on the misrepresentations, the expert's own say-so, which is all his report was, it was the expert population of one saying, I think the disclosures are misleading. That's not even a relevant data point in evidence. Who is the expert to decide? In fact, there's case law saying that when it comes to whether common unsophisticated people can understand a disclosure, in some ways an expert is the worst person to opine on that. And so there's no evidence, even with that expert report, as to either misrepresentations or especially materiality. And with that, I would ask the court to affirm.
Thank you. I think you asked for a couple minutes.
I did, and I'll be mindful of the court's time. I'd like to start with friend sharing. I think my friend, Mr. Lipschitz, said that this was disclosed over and over and that every court had to look at it has rejected it. That's simply not true. If you look at the consumer case from the Northern District of California, and I'll quote, it said, virtually no one consented in a layperson sense to friend sharing because it would have been difficult to isolate and understand the pertinent language in Facebook's complicated disclosures. That is an outright rejection of their claim that nobody would have been confused by this. The second point I'll make is that Facebook's own internal studies prior to Cambridge Analytica showed that users did not understand this. And I think the best evidence for that is 4095 and 4464 of the record, which show their own studies saying people couldn't even figure out where to find these things on the website, and they were confused and didn't understand the concept of friend sharing. The next point I'll make is to the questions from Judge Deal and Judge McLeese about what do you do if on page 1 of the disclosure, it says one thing, on page 72, it says another thing. I think that's really analogous to the Center for Inquiry case, the labeling case, where you have a front-facing statement that makes one broad affirmative representation, and then you have some details buried far on page 72. And I think that's exactly what we have here, but kind of in a digital context. The front-facing statements from the privacy settings, and again, I'll point the court to page 1526. That page does not have anything about friend sharing on it. It doesn't have the sentence that he quoted. People trying to decide what their privacy settings were would not have encountered that statement.
Do you think it's different if to buy the cough medicine and you go up to the counter? I realize this in the cough medicine case, it was over the counter, but pharmacist says, have you read the back? And you say yes.
I think that's a little different than kind of our modern age where everyone knows that nobody reads those giant disclosures. I mean, I suppose that gets you a little bit closer. But I think the Center for Inquiry case, the Bellevue Publics case, and talk about how even the placement on the shelves can be misleading to someone. So I think if you're operating in that world, having a bunch of fine print really doesn't get you out of it if you have kind of front-facing statements that convey a different impression. I think Earth Island, again, is a similar example. Those were pretty broad public statements on a website. And I don't think you can kind of get out of that by having some footnote that says, oh, by the way, Coca-Cola still actually makes a ton of trash and puts it in the environment, when you have these kind of broad statements at the front. The fourth point I would make goes to Judge Deal's question about, isn't it different to kind of say my spouse and family have access to this information versus this information is going to get spread all over the internet to a bunch of third parties that I don't know. I think that's an obvious difference. And I would say, if you want to have evidence of that, look at the recent TikTok case. The main problem that was being addressed there was that people who downloaded TikTok swept in all the contact information from their phones, from their friends. Those are obviously phone numbers and contact information that the friends voluntarily shared with the person. Doesn't mean that they decided to voluntarily share it with TikTok when it kind of all gets swept in by the app automatically. That's much more close to what we have here with friend sharing. I think it's a world away. And then the next point I would make is just on enforcement. They said that there's no examples other than Cambridge Analytica of a failure in their enforcement. That's just not true. Problem is that all those examples are in sealed portion of the record. I'd point to page 30 and 31 of our brief where we kind of outline and summarize those examples. On materiality, I would just say that Judge McLeese, your question gets it exactly right. It's about whether it's important to the decision, not necessarily whether it's outcome determinative to the decision. I think Earth Island is a great example of that again, where the court said there's surveys showing that people care about environmental sustainability. It wasn't that people would have made a different decision about buying Coca-Cola based on environmental sustainability, just whether they care about that concept. And to the extent that there's no evidence that, supports our materiality claim, I would point to page 3789 of the record where Mark Zuckerberg testified that people certainly would have considered this an important piece of information when making a decision. I would also point to page 5065 and 5166, which are Facebook's internal studies of what was happening post-Cambridge Analytica, where there was obviously a huge public reaction to this, and there were surveys showing people really did care about it. So the idea there's no evidence about materiality is simply false. And the last point I will make is on the expert, where he said that readability.com is not reliable. That's page 1129 and 1264, where he testified that it is something he has used in his peer-reviewed research in the past. So again, that's simply not true that there was no evidence of reliability on that. And unless the court has any further questions, we would ask the court to reverse.
Thank counsel for their briefs and for their arguments. And this case is submitted and we now stand adjourned.